Lordship, I beg to mention item number 8 for withdrawal. I beg to withdraw item number 8.
You want to withdraw?
Yes, Lordship, the petitioner has expired, so the matter is.
What is the matter about?
I'm for the respondent.
What is the matter about?
No, this arises from a Ms. J case, my lord, in the proceeding pending before the learned tasteful court. While the main suit is not stayed, but this Ms. J, my lord, arose out of a violation of a temporary order of temporary injunction. He has passed away. The petitioner has passed.
So there is a Miss
K. Bhattacharya.
Evachajil, the learned counsel appearing on behalf of the petitioner, submits that the petitioner had expired.
Yes, Your Lordship.
Gusto. There was an order of violation.
Yes, my lord. There was a temporary
Temporary.
order of temporary injunction in our favor. You know, that the allegation against him was that he has violated it. Now his legal heirs have been substituted.
And as such, the instant proceedings cannot be continued, taking into account that the instant proceeding arises out of an order passed under Order 39 Rule 2A
Lordship.
against the petitioner.
Lordship.
Gusto. Taking into account the above, the instant proceeding therefore stands closed on withdrawal. Unabated, it will be
Abated,
abated.
my lord. He died on 3rd of
The
June last
court,
year.
taking into account the above, as the order passed against the petitioner was personal to him.
That, my lord, your lordship may perhaps
Huh?
not say, my lord, because in the order itself, my lord, there is an issue, my lord, their legal heirs have been substituted in the court below. And the-
Understood, but the violation order is only against him.
Him, my lord, but now they are running, my lord, that lordship may.
For
perhaps
that,
not-
it is a different thing. That, because that order is only specific against him, where is the
Him,
violation.
yeah.
So it was
That's my lord.
personal to him,
Lordship.
personal to him, comma. The instant proceedings cannot be allowed to further continue upon the death of the petitioner, for which the instant proceeding stands closed as it has abated. Mr. Ganguly appears on behalf of the respondents. Mr. Ganguly and Mr. Hawk, both of your matters, top of the list, will be taken up at 4 o'clock. Not before that.
Lovely.
FRD. FRD. Right away.
For motion item 3. Item 3.
And appears on behalf of the petitioner on call, list the matter after 2 weeks.
Four. Item 4.
And appears on behalf of the petitioner on call, when the matter is taken up. According to the matter, it is still up 2 weeks.
For admission item 5.
Yeah, the petitioner file a suit for specific, my lord, especially section 6, my lord. And that suit was dismissed, my lord. The petitioner, the plaintiff could not prove his case. But the Defendant also filed a counterclaim for special performance contract, my lord. That petition was allowed against
Ah.
that. Counterclaim plus WS, my lord, that is was allowed, my lord, by the learned trial for my lord. My lord, it is why, if my suit goes, my lord, I could not contest the, my lord, the specific performance contract allowed by the Learned Trial Court on behalf of the defendant, my lord. Because I have to file, and I am barred from filing any suit, further suit, and my defense is also limited in this regards, 115, my lord, this petition, my lord. CRPC, my lord, 115, my lord. That's why Learned Trial Court has to decide.
Mr.
only
Counsel,
the
first of all, in
section
a
6, my-
section 6 proceedings, the question of a counterclaim does not arise.
My lord,
Be that as it may, there is a counterclaim.
yes, my lord,
But the counterclaim, it is like a suit.
yes, my lord,
And if it is like a suit, you have to file an appeal.
that is problem arises, my lord, and my petition section 6, my lord, dismissed because I have to come under my lord CRPC, my lord, 115, my lord, against that.
Be that as it may, the question
My
is
lord.
you want the recovery of possession at the end.
Yes, my lord,
This is the proceedings when you were evicted on 2014.
yes, my lord,
We are taking up now. You are not still in possession.
yes, ma'am.
So
That
what
is
is required to be done is you should file a suit appeal. And if you want to recover the possession, you file a suit for recovery of possession, claiming right title interest.
Indirectly,
But
my lord,
without filing an appeal against the counterclaim, how can you proceed?
if we go, I go to file a fresh suit, it will hate by res judicata, my lord.
Why?
That is, they already, I filed a written statement against the special performance contract, my lord, that is right.
You see, you need to, there are two ways out.
My lord,
First of all, the question is, there is a counterclaim.
yes, my lord,
The counterclaim has been decreed.
yes,
Counterclaim is for specific performance which is decreed.
my lord,
So you are required therefore to file an appeal against that.
for my case, my lord, this is why it is.
Understood, but you have to file an appeal against that. The second is, as regards the
Is
for possession,
possession,
whether you are in
dispossession.
possession or not,
My,
that this court can very well take into account. That is one thing.
yes, my lord.
But that one can only say that the trial court did not decide it properly, merely on the
Yes.
ground that you have not filed an FIR.
FIR,
The court dismissed it.
FPS, my lord.
And the trial
Only
court
on-
also came to an opinion to that effect.
Right.
That look here, in the complaint when you have filed,
Yes, my lord.
the plaintiff was also a part, the defendant was also a party to that complaint.
107 and 1045, my lord.
In 2000,
on
in
that point, my lord.
107, when you
Only
filed
that point-
against one Ataur Rahman or
Yes, my lord.
something,
On that one, only Learned Trial Court said that. he is
Yes.
also possession.
why was the defendant there?
My
Because
lord.
defendant specific case is, after entering into the agreement for sale, the
sir.
possession was handed over. Whether
Yes, my
rightly
lord, on
handed
the
over or
symbolic
not.
possession, first symbolic possession, day of execution of that sale deed agreement, then full possession given, my lord.
When?
2011, 2017, my lord. 7.
You are for whom?
I'm for plaintiff, my lord.
So,
Plaintiff, landowner,
no, understood. Who has lost the possession? The plaintiff.
plaintiff, my lord.
So you filed the suit
Yes,
that on 5/10/2014,
yes, my-
isn't it?
yes,
You were dispossessed.
yes, my lord, on
The
disposition. on the-
defendant's case is, look here, when he had entered into an agreement with me, I have paid 2.5 lakhs.
Yes,
And
ma'am.
remaining 16 lakhs and odd, I have to pay.
Yes, my lord.
That amount I will pay at the
Exactly.
time of execution of the sale.
Sale.
But at that point of time, taking into account the threat of this person concerned,
My lord,
I was asked to look into that.
low into the property.
That is what has been
Yes,
given.
that is,
And the Learned Trial Court therefore holds that at the time when you were fighting against that other person,
yes, my lord. At all
he
wrong.
was also along with you.
Yes, my lord.
The defendant was also along with you.
That is why possession, dispossession could not, is not entitled for possession. Recovery.
So you have already lost the battle for all this while. Why you are not filing a suit? For recovery of possession, you file a suit. That is
Yes.
one thing.
Yes.
But you have to file a counterclaim.
Yes.
Not a counterclaim. You should
Fresh.
have, in fact, the suit was wrongly proceeded with.
Yes, my lord. Yes. Wrongly
But I can't touch the decree for specific performance.
I have to file fresh.
Huh?
It will, it also limitation, my lord.
The limitation, there is no problem.
My lord.
Because you say that you have been dispossessed on 5/10/2014.
14, my lord.
You are suit based on title.
Title, my lord.
So suit based on title, there is no limitation,
Limitation.
isn't it? As of now, he doesn't have the title.
Yes,
He claims the right through you.
right, to my.
So therefore, the question of adverse possession does not
Part
arise.
performance on there. On
No,
the-
the adverse possession does not arise.
Arise, my lord.
So you therefore have a right
Yes,
to file a suit.
yes,
But you also have a right to file an appeal. You have to file an appeal. Okay,
against that. Yes, my lord.
so you do one thing.
My lord.
I close this petition on your submission that you will file a suit
Yes,
for recovery of possession
my lord.
based on title. And as it was mistakenly you have filed this proceedings
Yes.
insofar as the counterclaim is concerned.
My lord.
The period for filing of the period during which the instant appeal has been pending,
My lord.
these proceedings be excluded while filing an appeal against the counterclaim. I think that seems to be the only way out.
My lord.
Otherwise, you are not.
My lord.
Yes.
Kindly taken up the matter after some time. My senior is on the
Who is
way.
your senior?
Mr. D Nandi.
Ask him to come. After so much of time has been lost. This court can't do better we.
15 minutes.
15 minutes, let me pass the order, then he may ask you. Now, you see, I am not doing anything. He is going to withdraw the suit. See, there are two aspects. One, first of all, the trial court made an absolute blunder. In a suit for under Section 6, there is a counterclaim being taken into account, which the trial court could not have. Anyways, the counterclaim was decreed. So when a counterclaim is decreed, it is a decree which is appealable. He cannot fight under 115. But on the other hand, if the suit is as regards the other aspect for recovery of possession, he will file a suit based on title. So against you, there is nothing. Leho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss, what's your name?
Please, sir.
So-and-so who appears on behalf of the respondent. Full stop. This is an application filed under section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 26/2019, passed in title suit number 405/2014 by the learned civil judge, by the learned court of the civil judge number 2, Kamrup Metro at Guwahati, whereby the suit so filed by the petitioner under section 6 of the Specific Relief Act 1963 was dismissed, and the counterclaim filed by the defendant, the respondent, seeking specific performance of a agreement dated,
Given that
what is the exhibit 6?
11.
14/11/2007. 14/11?
Yes, ma'am.
14/11/2007 was 14/11, na?
Yes, ma'am.
14/11/2007 was decreed. Pusto. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the plaintiff has title over the suit property has title over the suit property, comma, the plaintiff would be well advised to file a suit for based on title for recovery of possession over the suit land. He further submits that against the decree passed in the counterclaim, the plaintiff oblique the petitioner ought to have filed an appeal inasmuch as the decree passed in the counterclaim is a decree which is appealable. The learned counsel therefore submits that he may be permitted to withdraw the instant petition without prejudice to his rights to file a suit for recovery of possession based on title, as well as to file an appeal against the decree passed in the counterclaim, and the period during which the instant proceedings have been pending be excluded while computing the period of limitation in filing the appeal. Yes, Mr.
My lord, they preferred an appeal, they have withdrawn it. This is the order. Before this lordship,
Wait,
yes,
Yes, my lord.
why?
Because TCRP is pending, my lord. That is why we told my lord.
this is the order.
What is wrong with you? How this court can't help you? A liberty has been granted. Liberty has been granted.
Liberty was,
The learned counsel further submitted that learned counsel for the petitioner further submitted that the appellant had filed an appeal against the judgment and decree passed in the counterclaim, against the decree passed in the counterclaim, which was registered and numbered as RFA number 6/2020 before this court. But the said counterclaim appeal was withdrawn with liberty, which was permitted by this court by an order dated 5/2/2020. This court have duly given its anxious consideration into the matter. First, and heard the learned counsel, this court have duly heard the learned counsels for the parties and have given an anxious consideration to the submissions so made by the learned counsels appearing on behalf of the petitioner. First, at the outset, this court finds it very pertinent to observe that proceedings under Section 6 of the Specific Relief Act are in the nature of summary proceedings. First, however, the learned trial court, that is the court of the civil judge, senior division,
Yes, ma'am.
senior division. First of all, it couldn't have gone to the senior division also. How can you do it?
Yes, ma'am.
Senior division, number 2,
Told my lord.
Kamrup Metro at Guwahati, have converted the proceedings under Section 6 into a proper suit proceedings by allowing the respondent herein to file a counterclaim. Be that as it may, the counterclaim was decreed. The counterclaim which was filed for, be that as it may, the counterclaim which was filed for specific performance of the agreement for sale dated 14/11/2007 was decreed. In view of this, in view of the manner in which the learned trial court allowed the proceedings under Section 6 to be converted proceeding, section 6 proceedings to be no. The manner in which the learned trial court conducted the proceedings under section 6 filed by the petitioner have resulted in this state of confusion as to what the petitioner is required to do. The resultant effect is that the petitioner had filed an appeal being RFA number 6/2020 against the decree so passed in the counterclaim. But later on, taking into account the instant proceedings, which was also filed under section 115, the petitioner withdrew the said appeal with liberty to file so. The anomaly has arisen in view of the mistake on the part of the court, trial court, learned trial court, to allow the section 6 proceedings to be converted to a normal proceedings, normal suit proceedings, thereby permitting a counterclaim to be filed. Under such circumstances, this court is of the opinion that certain corrective measures is required to be made. This court further takes note of the submission made by the learned counsel appearing on behalf of the petitioner, who submits that as on date, the petitioner has title over the suit property. And as such, the plaintiff, the petitioner, can very well file a suit for recovery of possession based on title. Taking into account the above, this court, this court further takes note of that the appeal, though filed, was withdrawn with liberty. Under such circumstances, on the ground that the petitioner bona fidely believed that the proceedings under the present proceedings would be the proper proceedings for challenging the judgment and decree dated so and so. Taking into account the above, this court therefore disposes of the instant petition with the following observations and directions. Number, the petitioner herein would be at liberty to file an suit for recovery of possession based on title. Before the court of the competent jurisdiction. Number 2, the petitioner is given the liberty to file a fresh appeal against the judgment and decree dated so and so, insofar as the counterclaim is concerned. First, the period from the date of filing of the instant proceedings, that is 3/9/2019, till date, be excluded while computing the period of limitation for the purpose of filing the appeal against the counterclaim, against the judgment and decree dated so and so in respect to the counterclaim. With the above, the instant proceedings that is disposed, full stop. Number 3, full stop. the decision of the learned trial court, the judgment and decree of the learned trial court dated so and so in title suit number so and so, insofar as the suit is concerned, shall be restricted, shall be restricted only shall not prejudice the petitioner in the suit in the suit to be filed for which the liberty is being granted, and the decision so rendered therein in the suit and not in the counterclaim shall be construed as a decision only in respect to a proceedings under section 6 of the specific rule. Yes, Mr. Paikia. You should have pointed out this one. The records returned. Yes, what is this?
Apology, Lordship.
You are
Item
not
number-
there when the motion is moved.
Item number 4, Lordship. I could not.
I thought that you don't want the dismissal, so let it go after.
No,
2
no,
weeks.
that was not my intention. But actually, I was under the impression that item number 1 and 2 will take some time. So
Be in the impression. Impression is very dangerous. Very good.
Item 6,
Wait till 4 o'clock to get it dismissed. Yes, Mr. Sahu, what are you challenging?
Lord, in this case, the petitioner has filed an application for issuing for framing a issue as regards the maintainability of this suit.
Where? What are you challenging?
My lord,
Which order are you challenging?
the order dated
Not studied properly.
12/5/22. 12/30. My lord, F2, if lordship, F2.
What to?
F2, I'll argue this case.
No, do.
Okay.
Now. There are 2 petitions filed.
Yes,
One is under 151.
yes.
151 is for stating that although by the order dated allowed the defendant to amend his written statement, however, in the petition filed by her, the amendment ought to have been sought for in paragraph number 4 instead of 3. According, the defendant has filed the instant petition again for amending the decision here. I've gone through the records and today there was a mistake in filing and the defendant sought for that is allowed. Now already the petition for amendment of here was allowed considering the prayer made by so and so. It has caused delay in the progress. This issue has also been framed accordingly. Defendant number 1 has again filed the petition being so and so, stating a preliminary issue regarding maintainability of the suit is to be framed. Now the question issue in these suits are already framed and the said trial is already started. Accordingly, here is also rejected. Now you want the preliminary issue.
Preliminaries.
Where is your petition?
Yes, at page.
Yes.
What are the issues framed?
Yes, my lord.
What are the issues framed?
Those issues are not here, my lord.
You know, what are the issues framed?
No, my lord. But from the order, issues has already been framed, my lord. Issues have already been framed.
It's still a matter of 2022. When were you engaged in this
23,
matter?
23.
23. And for the last 2 years, you don't know what has happened. Is this the sort of advocacy you do? Isn't it the saddest part of a profession? So why do you need it as a preliminary issue? The suit is at the stage of evidence. Then the stage is gone.
My lord, after issuing the notice, I have, after framing the issues, I have filed this application. Because, my lord, on the face of the report and the face of the plate, there is no mention of notice, my lord. Because as per section,
Go under order 7 rule 11. File it. Why do you need it under order 14 rule 2? So you have to say that it does not disclose of the cause of action.
cause of action.
Then why you're not filing order 7 rule 11A? Do I have to tell you? You are such an expert in civil law.
Otherwise, my lord, that not maintainable even if, yes, my lord, that is there, my lord.
Then why
I-
you not going or barred under order 7 rule 11D? Go there. And proceedings under order 7 rule 11 can be filed at any stage.
At least,
Then go, you are happy.
my lord.
And this order 14 rule 2 has to be taken as sacrosanct what is there stated in the plaint. So nothing remains. So what is there?
My lord, liberty.
No, what liberty?
No, to
I
fight,
should,
because,
you
because,
do whatever you feel
No,
like.
because this shall not.
I
bar-
will say that this is your submission.
My lord.
Although I put it as not my suggestion,
Yes.
put it as your submission, the clever Mr. S. Sahu he is. Leho.
And that part, my lord, because earlier, actually, my lord, amendment should have been sought in paragraph 4, but it was sought in paragraph 3. Later on, it was found that no, it was not required in paragraph 3, in paragraph 4. That part be allowed.
That has been allowed.
No, that part be allowed by your lordship. That was not allowed. You are right.
Let us see your petition.
That petition has not been annexed, my lord. No.
Then I am not.
They have annexed their WS, my lord, in page 21.
Wow. No, where is your amendment order? That also you have not enclosed.
Not annexed.
Sorry, I can't help you. Truth has been stayed.
Yes, my lord.
Leho. Heard Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner. Mr.
S.N. Borua.
So and so appears on behalf of the respondents. Number?
1, 2, 3, and 4.
Respondents numbers 2, 3,
1, 2, 3, and
1, 2, 3, and 4. Full stop. Mr.
Here go, my lord. 5 and 6.
So and so appears for respond number 5 and 6. Mr. 7 and 8. And who appears for 9 and 10? Who are 9 and 10? Performer.
My lord.
Who is 9 and 10?
Yes, 9 and 10 perform, my lord.
Unnecessarily to delay the proceedings we have done. So none appears on behalf of the respond number 9 and 10. Full stop. The present proceedings, the supervisory jurisdiction of this court has been invoked, challenging the order dated 12/5/2022, passed in title suit number 09/2020, whereby the learned court of the Munsif at Udalguri had rejected 2 applications filed by the petitioner, who is the defendant number 1 in the said suit. First, the first application pertains to a petition filed under section 151. Which is petition number 416/2022, whereby the defendant, the petitioner, had stated that although the amendment was allowed on 8/3/2022, to amend her written statement. But the amendment which should have been allowed is in paragraph number 4 instead of paragraph number 3. And therefore, the petitioner sought that this correct mistake was on account of wrong drafting, inadvertence of the counsel, which have resulted in prejudice being caused to the defendant number 1, for which the said application should have been allowed, said application be allowed. Full. He further said, yeah, full. The second application is a petition, is an application filed under Order 14, Rule 2, which have been registered as petition number 415/22, whereby the defendant number 1, the petitioner who is the defendant number 1, had requested the court to frame an preliminary issue as regards the maintainability of the suit on the ground of violation of Section 54 of the Assam Temporarily Settled Areas (Tenancy Act 1971. Full stop. The learned trial court, that is the court of the learned Munsif Dalguri, had rejected both the application, and it is under such circumstances the present application has been filed. Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner, submitted that the learned trial court, taking into consideration that the amendment was necessary, have permitted the amendment by an order dated 8/3/2022. Full stop. He submitted that there was an inadvertence in seeking the amendment in respect to the paragraph number 3 of the written statement rather than in paragraph number 4. He therefore submitted that this technicality on such it is the case of certain procedural technicalities which the learned trial court ought to have allowed. Full stop. In respect to the application filed under Order 14, Rule 2, the learned counsel submits that although the issues were framed, but the fact that the amended pleadings were permitted to be filed, there would be requirement of fresh issues, isn't it? There will be.
No, my lord, they want to change a typographical mistake, my lord.
You see, there is when you allow the amendment, the suit goes back to the stage of pleadings. Then only the issues will come. With it that as the amendment was allowed by the learned trial court, the suit relegates itself to the stage of pleadings. And as such, the question of rejecting the application on the ground that the issues were previously framed is not in accordance with law. Full stop. Anything more? You even didn't submit that.
My lord.
What is your submission?
My lord, regarding amendment, my lord, I do not have any objection, my lord. But regarding the framing of preliminary issue, my lord, apparently as per the act, my lord, what they are saying that notice is required, it is not required, my lord, because
That I am not deciding. I am not going to decide whether the issues is there. Mr. So-and-so appearing on behalf of Mr. So-and-so who appears on behalf of the respondent numbers 1 to 4, who are the plaintiffs, submitted that the mistakes in question was a technical mistake in respect of amendment, which was allowed by the order dated 8/3/2022. He would not oppose the he would not oppose insofar as the application, so far as the rejection, so far as the rejection of the petition number 416/2022. However, in respect to the framing of the preliminary issue, he submitted that the preliminary issue sought to be framed is nothing but a ploy employed by the defendants to delay the proceedings of the suit. Full stop. This court have also heard the learned counsels appearing on behalf of the other parties. Full stop. Upon hearing the parties, and giving an anxious consideration, this court duly takes note of that the amendment, the application which was filed under section 151 is this court have duly heard the learned counsels for the parties and have perused the materials on record. Full stop. Full stop. It is seen that the learned trial court, by an order dated 8/3/2022, have permitted the amendment. Full stop. Pursuant to the amendment being filed, the amended written statement being filed, it came to the notice of the. Did you file the amended written statement or not?
Because, my lord,
You did not file.
this was not allowed. Thereafter, we came before your lordship.
So you have not filed the
You have not
amended.
filed it.
Full stop. At the time of making the full stop. At the time of preparing the amended written statement, which was required to be filed, comma, it was noticed that the amendment which was required was in paragraph number 3, but not paragraph number 4. Full stop. Taking into account the above, comma, and more particularly when the suit was in the said suit, the trial had not started.
Initially, they sought amendment for paragraph number 3, my lord. But later on, they filed an application that not for 3, but amendment for 4.
4. To 3-4 করে দিব। 3-4 করে। Yeah. That the trial of the suit has not begun, comma. This court is of the opinion that the learned trial court ought to have allowed the said application, but by imposing certain costs. First, in respect to the application filed under Order 14, Rule 2, comma, the reasons were assigned by the learned trial court that the suit had proceeded to the next stage after framing of the issues, in the opinion of this court, is not the proper exercise of jurisdiction. More so, when the learned trial court in its order further states, have duly mentioned that the plaintiff side may take steps for implement of the legal heirs of the defendant number 7. Full stop. Considering the above, this court interferes with this order dated 12/5/2022 and disposes of the instant proceedings with the following observations and directions. Full stop. Number 1, the petition number 416/2022 filed by the petitioner, who is the defendant number 1, is allowed. Full stop. This court further takes note of that there has been certain negligence on the part of the petitioner which have resulted in the delay in the disposal of the suit, for which this court imposes a cost of rupees 15,000 upon the petitioner. Full stop. This court further directs the petitioner, who is the defendant number 1, to deposit the said amount along with the amended written statement to be filed. And the depositing of the said amount would be a condition precedent for acceptance of the amended written statement. Number two, this court further grants liberty to the plaintiffs to file an application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders. Then next, this court further interferes with the order, further allows the application being petition number 415/2000/22 and directs the learned trial court and directs the learned trial court to this court further interferes with the decision dated 12/5/2022 insofar as petition number 415/2022 and restores the petition number 415/2022 to the file of the learned trial court to decide afresh as to whether the preliminary issue is required to be framed or not. The same shall be done so without being prejudiced by the order dated 12/5/2022 as well as the observations made herein above. It is further seen, next, this court further takes note of that by an order dated 30/6/2022, this court had stayed the further proceedings of title suit number so-and-so 9/2020. The said order stands vacated and the parties herein are directed to appear before the learned trial court on 11th of June 2025, on which date the respondent herein, the petitioner herein shall file the amended written statement as per the observations made herein above without fail. It is further observed that if the amended written statement is not filed on that date, the consequences in terms with Order 6 Rule 18 shall ensue.
Item 7.
It may be 10.
Huh?
The cost may be less than to
Okay,
10.
15,000. Hey, this is what? This is different matter or same matter? 15, huh? আগতে কিমান দিছিল? আগতে? 15 is required. Then these people get taught.
Otherwise, this is on the part of the council. This mistake was on the part of the council.
So we make it another 10,000 upon the council, make it 25. Come up with all this. Councils are equally responsible. You have delayed the proceedings. Yes, what is this?
May I please, Lordship? This is matrimonial appeal against the matrimonial appeal, Lordship,
Matrimonial appeal.
against the judgment and decree passed by the learned additional district judge Sonipur at Tezpur in matrimonial title suit matrimonial 138/18, Lordship. So
Divorce.
Yes, Lordship. Divorce. However, declaring in the favor of the petitioner respondent, Lordship.
Huh?
Petitioner respondent, Lordship. Now. Yes,
You don't want to give divorce.
Yes, Lordship.
Why?
Actually, Lordship, we want to stay with him, Lordship.
Why?
I want to stay with him.
Since how long you have been staying separately?
Almost, Lordship, since 2014, Lordship.
Then
But-
after 11 years.
In fact, in this case, Lordship, decree is given, Lordship, but in the favor of the petitioner respondent, but alimony part is very silent in judgment, Lordship. This is also one of the reason, Lordship. And my
Did you ask for alimony? But
Yes,
this is on the grounds of cruelty
cruelty and desertion, Lordship.
and desertion.
Desertion, Lordship.
So if it is cruelty or desertion, there cannot be any alimony. I'm asking you.
Yes, Lordship.
I don't do this family matters much, but tell me, I am into RSA.
Yes, Lordship, but my respectful submission before this honorable court, if the cruelty or desertion.
You have deserted your husband.
That is the reason, Lordship. On my, I have not given the reasonable opportunity to produce my evidence also in this case. Lordship.
Do you expect this court will give you?
This is my submission only.
Mental cruelty. You deserted from 1612. What is there? Let us dismiss this, finish this agony amongst the parties. Dismiss.
Lordship, in fact, I may be given one opportunity to that there may be some improvement, Lordship.
What?
Was that part of the alimony also, but
List this
my responsibility.
appeal at the stage of Order 41, Rule 11, as to whether to decide as to whether the instant appeal can be proceeded with without proceeded as to to decide list the appeal at the stage of Order 41, Rule 11.
Item 9.
The meaning is this. This is not for admission.
Yes, yeah.
It is a date hearing fixed.
Yeah.
You have to be ready.
Yes,
Otherwise, I'll dismiss it.
Lordship, deeply obliged. I'll try to convince your Lordship on that. Lordship.
Otherwise, you have to advise your client not.
Yes, Lord.
Yes, what is this?
The ex parte order passed by the additional district judge in a land compensation matter, it was referred to him under section under the provisions of the land
Huh?
National Highway.
What order you are challenging?
This order is at page 43. Before that, your lordship may kindly see page,
What ex parte?
yes, ex parte without hearing me, man.
How?
That is in respect of, well, the petitioner has purchased 14 acres of land in the year 2001. The 2016 notice was issued for acquisition of 5 acres of land. His 5 acres of land. But he then realized when his dark number is 107. Actually, should have been 107, but in the sale deed it is written 111.
Hmm.
So therefore, he has, his matter was also forwarded. Page 38, your lordship will kindly see. Page 38.
What is the name of the petitioner?
Petitioner's name is Amit Kumar Bora, and he bought the land from Paniram Bora, but his son, after his death, my son is objecting that he should not.
And you are fighting against whom?
No, we are fighting against the order, ex parte order of the additional district judge,
Why?
because he has passed the order without hearing me.
Where you are party there?
Yes, I was, it was referred by the additional deputy commissioner. Page 38, your lordship can see.
And then
Page 38.
upon
You are hereby
at whose instance it was referred?
the additional deputy commissioner.
At whose instance it was referred? It was found that there was a dispute as to who is to get it under 384. So it was referred. Then did you receive notice?
Passed the order without hearing me.
Peruse the written statement along with the letter of reference bearing number so and so. Contended that so and so. Answering and yeah. Now what happened to you?
No, I was not heard. That is the case, man. Otherwise, I would have pleaded my case, man.
So your only case is that you were not
Yes.
issued notice.
Yes.
That's all.
Yes.
Hello. So we have to call for the records. Have the records been called?
It's pending for a compensation amount is lying with the authorities, my lord. So
Very good.
I pray, my lord, your lordship will set aside and allow petitioner
How?
to hear.
But if you have been issued notice and you have not appeared, then why should I allow?
Notice, not, it is
Forget
pending.
about them. I'm not on that. First of all, Mr. Where is the order sheet?
If it is not there, they will have to there.
Why they will produce? This is before an authority. What is this? They are not to produce out here. This is a 227 proceedings. If you have received the notice here, Amit Bora is clearly mentioned.
Yes, Amit Bora is clearly mentioned.
So
But
whether
he has not
notice was
received.
issued or not,
I'll show the order sheet to lordship once.
where's the order sheet? You want to produce the order sheet, you produce it. Treat case called interim. Vacate the interim.
Vacation of the interim at this stage. This is a case pending.
Not satisfied.
Nobody has filed affidavit.
Uh,
Nobody that in respect of the 5 acres of land, there should not be disbursement. This is the order.
Absolutely no. First of all, somebody is losing out.
No, somebody means I am losing out.
You are losing out. You have to therefore show me that no notice was issued. Kindly see this record. There no notice has been issued to me and they have decided it. Your only ground is that.
You will fix it another day.
Okay, no interim extension.
Well, interim order is already in existence.
What type of orders I do?
Lordship will not cause
When do
injustice.
you want it?
Next week, after 10 days.
Leave the matter next week. On 28th of May 2025, at the request of the learned counsel for the petitioner, whose the interim order passed earlier shall continue only till then.
Item 10,
Technically, leave the matter on so and so to enable, so as to enable the counsels appearing on behalf of the petitioner to produce the order sheet of the proceedings before the court of the additional, what is that court?
Judge,
District Judge
Sure.
Churhat. In LA case number? What is the case number?
Reference number, land acquisition, reference number 30/22.
Interim, reach the matter to determine, interim order shall continue till the next. Yes, what is this, Mr. Sheikh? What are you challenging?
Shoot for ejectment and
Huh?
first possession, shoot for ejectment and first possession. Now question is regarding this temporary injunction. Your lordship would be pleased to see the page 64, impugn order. Relevant portion at page 82.
So what is wrong with that order?
No, my lord, my humble submission before your lordship, page 82, it is said that if construction is raised, share of the land is sands. In that case, my lord, if I win in the case, in that case, my lord, that construction may be destroyed. But in that case, my lord, my humble submission before your lordship, if that is the position, that construction will be raised and thereafter on destruction of the construction, I will get after decree. That is not the position one position of law, then that order 39 will be redundant, my lord.
Why?
Your lordship will turn to page 82. In the middle portion, my lord, moreover, the suit is for recovery of possession and eviction of defendants, respondents from the scheduled land. And if the defendant respondent make any construction over the suit land, definitely they will be doing so at his own risk and peril, getting demolished on the decree of the suit. My lord, if that position is upheld, my lord, then what is the necessity of temporary injunction? And order 39 will be redundant, my lord. There is a purpose for the same. Why construction, my lord, land is vacant and why construction will be allowed to continue?
What are they going to do?
My lord. They are the agricultural land, my lord. Let them continue with agriculture, not to construct and change the nature of the shoot land, my lord. It is my purchased land that they admitted it.
Oh, they are constructing a prime minister, this one?
PMJ.
PMJ.
Your lordship. Your lordship,
That
may I
cannot
just
be
take
allowed,
one
my lord.
submission? Your lordship. Here, your lordship, the seller, he is one of the legal heirs. There are a number of legal heirs, about 10 of them.
they, in the suit, they have not sought for partition. It is just for recovery of khas possession and for declaration. So, as your lordship has stated in some of the earlier cases, in such a case, although he is entitled to the to a share of the property, until and unless partition and demarcation is done, he cannot arbitrarily seek injunction over a certain part. The fact that this particular share is his share, it has not been established. So he has arbitrarily sold a certain part of the land, which is undivided property. Your lordship.
How much is the land?
2 katha is the part he has sold. However, the entire land is, your lordship, 1 bigha, 3 katha and 6 acres.
Huh?
1 bigha, 3 katha and 6 acres. Your lordship.
Let's see the plaint. Nowadays, at that stage of plaint only, I try to dismiss the suit only.
Plaint starts
You
from
lay 2 kathas.
page 12, my lord. Page
Ah,
12.
then? Why only 2 kathas?
Because, my lord, I have purchased 2 katha and it is mutated in my name. Your lordship will see at page 42, their statement, my lord. That land is sold out by Madan Ali. And mutation also done, page 42, my lord.
The petitioner, your lordship, is the buyer.
Page 42. I purchased the land. They are in possession, they are not vacating the land.
What is your right to construct?
Your lordship, what has happened is the property devolved upon the legal heirs. The legal heirs.
How are you connected with the defendant?
The defendant is one of the legal heirs, your lordship. We are also legal heirs.
He claims that he has, this is the, these 2 kathas of land.
Yes, your lordship. He is the purchaser, but the purchase has been made from one of the legal heirs. The purchase, he is the purchaser. The purchase has been made from one of the legal heirs, but the right of the legal heir who sold the property, that itself was not established. He was just holding the.
I'm not on that. The question is, have you challenged the sale deed?
No, your lordship.
So therefore, what has happened is, these 2 kathas of land, which is there, has been sold with boundaries.
Yes, my lord.
Yes, your lordship.
With boundaries has been sold. And therefore, he has a right over the land. Then how can you construct?
But your lordship, he has not paid for partition.
Why should he ask for partition? He is asking, he may not ask for partition. He may feel that, okay, it is not a question of partition. He only steps into the shoes. You are not in possession.
I'm in possession, your lordship.
How are you in possession? Were you in possession prior to that?
Yes, yes, we have all together been in possession. We have all together been in possession.
You have to challenge the sale deed. Without that, can you construct? You'll have a big problem.
Your lordship, the trial court has gone with that issue. Paragraph 7, it has stated that any construction or whatever has been done by us, at the end, if the suit is decreed in their favor, the same can be demolished by issuance of writ and any damage.
Where?
At paragraph 7, the trial court order, initial order, your lordship. At page 62, your lordship, paragraph 7.
On the other hand, any loss that might have been sustained by with regard to any construction orders, the same can be easily remedied by way of execution of a writ and can also be compensated in the form of monetary damage if he is successful in proving his claim. So this is what he has stated. That is not that, but where is it?
Page 82, my lord.
Huh?
Page 82, your lordship would be pleased to see that construction will be there. If I win the case, I will destroy that. Can it be? Then order 39 will be meaningless, my lord. That is my land, they will raise construction.
The suit is for recovery of possession of the.
Let them continue with cultivation till the continuation of the suit. But why construction?
Going to
Your deep pond, they will raise construction. That cannot be, my lord.
Illegal occupation cleared by demolition.
All issues will be decided in the suit. Who will win and who will win.
Huh?
All issues will be decided in the suit, my lord, whether they are liable to be ejected, whether I am entitled to the land. But during pendency of the suit, my lord, how construction can continue? That is the question.
Your lordship, what has been
No,
constructed is
they
already.
they are in,
You finished construction.
No, it is already here. It's a part of the judgment, your lordship, the appellate judgment that.
Has your construction been finished or not?
no, my lord, not construction, please.
It is
it
clearly
is-
stated,
it
your
is-
lordship, that
my
the
lord,
dependent
I-
number one.
No,
have
no, no.
constructed-
Tell me whether your construction is completed.
Yes, yes, your lord.
Are you staying there?
As per the pleadings, it is,
I'm asking you, staying there
No, my lord.
yes, we are staying,
in the constructed premises?
yes, yes.
Hello. Maintain a status quo as regards no more
Yes, ma'am.
construction.
Status quo will do,
You say
status
that
quo.
it is completed.
As
He
on
says
today.
that it is not.
Not.
Answer is very clear. You cannot further construct.
Your lordship may give me some time, I'll take some oral.
Okay, very well. 12.5. 12.5.
Yes, my lord.
Find out what is it.
Yes, your lord.
You do one thing. If you have to construct, then because it is after all a PMJY loan. One thing I have a very difficult proposition, one thing I'm finding it very difficult. You don't have an independent source of title except through your legal heirs, through your predecessor. Now, you have not challenged the sale deed which have been executed by one of the co-owners. And with specified boundaries. So without challenging that, you may have a lot of problem. Your prima facie case or your case, he has a good prima facie case. The balance of convenience is also in his favor because after all, there cannot be any construction. Now, if you say that yes, if any construction is there, I give an undertaking that I will demolish the year, but you cannot demolish taking into account you have taken PMJAY. Isn't it? So that you cannot give that undertaking. Now, if you construct, what are the requirements of a PMJY? Because if you have taken a loan for construction, then it follows with its certain requirements from the government also. So you cannot demolish also. Now, can you give it to him? You cannot give it to him also. So what is to be done? So think about it. 12.5.
Oblige.
Stay matter 41.
12.5. Yes, what is this?
Well, here I'm having some difficulties because on number of occasions, I tried to contact the petitioner, my lord, but I really failed, because to my knowledge, my lord, they have settled this matter out of court.
Settled?
They have settled, my lord, but it is unconfirmed because when I asked for.
How can it?
I asked for a written note from my client, my lord. So this is just 2 lines that you have settled this matter. So there is no point of agitating this matter. She didn't give it. Even my office also, my lord, on a number of occasions sent WhatsApp messages, no reply. She saw it, no reply. So what I feel, my lord, I need to issue, so following this civil manual regulations, my lord, I need to issue one letter stating that I want.
I vacate the interim order.
My lord, there is an interim order. Interim order is there.
I vacate it.
My lord, what I say, my lord?
No, you don't say anything. I vacate it. As you don't have any instructions against
My
that
lord.
matter. So the moment you vacate it, they will come running back to you.
Well,
Then
my-
you
I-
become the main person.
My lord, it against my principle, my lord, because on number of occasions.
Your name,
SP Bhattacharya.
Mr. S.P. Bhattacharya submits that he was informed by his clients earlier that the matter has been amicably resolved.
My lord, verbally. I was not.
That is what. Under such circumstances, he sought for a written confirmation from his client, which have not been provided. He further submits that in the meantime, the petition, he and his office have been pursuing with the petitioner, but they have not contacted with the
Very correct.
petitioner. Full stop. He therefore submits that he has no instructions in the matter. Full stop. Taking into account the above, it appears before this court that the petitioner is not interested in the proceedings. First, list this matter again on 13th of June 2025. First, this court vacates the interim order passed by this court on 6/11/2020. This court further directs the learned district judge, West Siang District at Upia, to proceed with the divorce case being TS bracket D 41 oblique bracket YPA 2019. First, the registry is directed to forthwith inform the learned trial court about this order.
Very obliged.
I'm here now. 5 minutes is baat mein.
So
Yes. On that date, it a lot of inconvenience. Today in the morning, we are taking it up. Tell me,
Lord,
you are well?
this revision petition is preferred against the order of rejection of the application under Order T26 Rule 10A, my lord, praying for scientific understanding the fingerprint of the opposite party plaintiff for scientific investigation. My case in brief is
Why do you need the signature?
here,
Why do you need the thumb impression?
signature. My lord, in the cross-examination, my lord, when the question was put, he denied that he put the thumb impression on the, there is a Katsa seal deed, my lord. The petition was rejected because as per section 17 of the Registration Act, as it is compulsorily registrable, so the learned court came to a finding that is not valid in the eye of law, that is why petition was rejected. My lord, in the.
What are you, why are you using this Kacha sale deed for? In your suit, you are the defendant.
Yes, I am the defendant, my
What
lord.
is your pleadings on respect
My
to the
lord,
Kacha sale
pleading
deed?
is that rupees 40,000 was taken from me by the opposite party plaintiff, and a Katsa sale deed was executed, and I was given possession, my lord. Since
In the Kacha sale deed, was it mentioned the possession is handed over?
Yes, my lord, it is in the plaintiff itself, my lord. Possession at page 21, para 9, my lord. There is a little ditch covering an area of about 1 katha over the land, and the defend number 4,
Where?
top of the page, my lord, page 21. Internal number is 4. There is a little ditch covering an area of about 1 katha over the land, and the defend number 4, Musammat Alimon Nesa, was also allowed to live in a small portion of land, my lord. So since then I am in possession, my lord.
So, this is admitted. Why do you need that document then?
My lord, document where I prayed
So
for
at best, you will be a permissive occupier.
permissive occupier,
So,
but as the sale deed was denied, that is a Katsa sale deed, no doubt. The learned court below was not inclined to
rightly so.
send it. But
Right.
it is a discretion of the court, and if the court finds that it is expedient and to explicate the truth, my lord, and determining the controversy raised in the
There's no
suit.
controversy raised.
Well, controversy there.
This document cannot be construed to be a sale. They have already admitted that you are in possession. Why do you need this document?
Your declaration that the suit for declaration that mutation obtained by me is.
You cannot obtain the mutation on the basis of a.
Also cannot, my lord. That true, that is true,
Hello.
my lord.
Heard
But even then, my
Mr.
lord,
B. Chaudhary, the learned counsel
My lord.
appearing on behalf of the petitioner, Ms. P. Bachchaji appears on behalf of the respondent numbers.
Sole respondent.
four, my lord.
Sole.
Four, 1, 2, 3, they are government respondents.
Respondent number 4 and Mr. T.R. Gogoi appears on behalf of the respondent numbers. Well, no, these are not government.
Government, there is government. my
Appears
lord.
on
1, 2,
behalf of
3.
the respondent number 4. There's no opposite. There's only one party.
That
You are
one
a
four.
plaintiff.
Yes,
Only
but
one.
under plaintiff, only sole respondent.
Sole respondent. Full stop. The petitioner has invoked this the supervisory jurisdiction of this court, challenging the order dated 25/7/2024, passed in title suit number 03/2021 by the court of the learned
Munsif Lakhimpur, my lord.
Munsif number 1, North Lakhimpur, whereby the petition being registered as petition number 860/2024 was rejected. So it is relevant to take note of that the petition number 860/2024 is an application filed under Order 26, Rule 10A of the Code of Civil Procedure 1908, or short the code, seeking scientific examination
I may be
of
excused, my lord. There was another petition also under order 14, rule 5.
Ah.
And both the petitions were disposed of jointly, my lord. Order 14, rule 5 petition was also there. That was partly allowed.
that was allowed.
That was partly.
What was the other issue? Whether the suit is maintainable in the present form and manner. That
Yes,
is,
and second, that was
the
partly allowed.
plaintiff has handed over the possession of the A after
Yes.
receiving money. So receiving money cannot be there. That fact, you want to put it, these two issues. You want the other issue also. Have you raised it in your pleadings? Have you raised it in your written statement? So this will be an issue then. We have no objection.
Otherwise also, Lordship, that point was raised before in the WS Lordship, thereafter issues are framed, then that point of time, no.
It's okay. The court can frame this issue at any point of time. It is based upon the pleading, let it be framed. Whereby the petition number, okay, Leho. The supervisory jurisdiction of this court has been invoked by challenging the order dated 25/7/2024, passed by the learned court of the Munsif number 1, North Lakhimpur, whereby the learned trial court, that is the learned trial court, whereby the petition number 860/2024 was rejected and petition number 905/2024 was partly allowed. Full stop. The question therefore arises as to whether this court is required to exercise its supervisory jurisdiction in respect to the impugned order dated 25/7/2024, impugned in the instant proceedings. Full stop. Insofar as the petition number 860/2024, it is seen that the said petition is an application filed under Order 26, Rule 10A, seeking scientific examination in respect to the thumb impression in Exhibit Core. Is it at the stage of issues?
Now it is at the stage of argument, Lordship, yes.
Arguments?
Lordship,
Argument stage, my lord.
And they have filed this.
Lordship.
Argument stage, my lord.
Whereby seeking scientific examination of Exhibit Core. Full stop. The other application being petition number 905/2024 is an application filed under Order 14, Rule 5 of the CPC, read with Section 151 of the Code, seeking, thereby requesting the learned trial court to frame two additional issues. First, it is seen that the learned trial court had rejected the petition number 860/2024 on the ground that the question of sending the thumb impression to the for scientific examination does not arise in as much as the said Exhibit A cannot be taken into consideration, cannot be taken, is not admissible in law in as much as it is a unregistered deed of sale of for a consideration of 40,000 and which is compulsorily registrable in terms with Section 17(1) and 49 of the Indian Registration Act 1908. Full stop. This court finds no ground to interfere with the said exercise of the jurisdiction insofar as the petition number 860/2024. Full stop. In respect to the petition number 905/2024, the learned trial court framed an additional issue as to whether the suit was maintainable in its present form and manner. Full stop. However, declined to frame the additional issue as to whether the plaintiff had handed over the possession to the defendant after receiving money from the defendant number 4. Full stop. This court finds it very relevant to take note of that the suit is at the stage of arguments when the impugned order was passed. Full stop. It is when the application being petition number 905/2024 was filed. Full stop. Taking into account that the learned trial court had already framed one additional issue and in its discretion did not find it necessary to frame the additional issue, this court would not like to exercise its supervisory jurisdiction in so far as the partly allowing of petition number 905/2024. Accordingly, this court finds no merit in the instant proceedings for which merit in the challenge to the order dated 25/7/2024, for which the instant petition stands dismissed. There is a stay
Yes, Lordship.
with cost of 15,040,
The cost may not be
cost of
imposed, my lord.
40,000.
Cost may not be imposed, my lord.
We have dismissed this petition.
But
Full stop. The
exhibit 4,
interim
my
order passed on 23/9/2024 stands vacated and the parties are directed to appear before the learned trial court on 4th of June 2026 for further proceedings of the suit.
Obliged.
It is exhibit core, my lord, not A, my lord. Exhibit core, not
Exhibit
A.
core. Koi kushu. You have disturbed so many times that so core has become A.
10.
The counsel, he tried to contact the client, but his number is switched off. So I leave it to you.
Mr. Sheikh,
My lord.
is your suit maintainable in this manner?
My lord, that is another aspect, my lord. whether it
No,
is maintainable.
that is most pertinent aspect. If the
Lord, that-
suit is not
That
maintainable,
will be decided by the court below. my lord.
absolutely, then you don't have a prima facie case.
My lord.
They deny your title. Okay? They deny your title. When they deny your title, you are not in possession. Without a suit for declaration, how can you proceed? And more particularly in view of the very recent judgment of the Supreme Court on that ground, we did dismiss your petition.
My lord, my humble submission before your lordship. I have mutation, I have purchased the land by registered deed. So my lord, my case is this, my lord, I have given the land for cultivation to them. So in that case, my lord, that section 34 will not come into play, my lord. of this
Forget about
proceeding.
section 34, your suit
Well-
is not maintainable.
No, my lord. Thing is this, my lord,
No,
under declaration.
No, it's for you to go to
Let me
Supreme
read
Court.
this section 34. my lord.
No means you have to go to Supreme Court. Let
Well,
me find out the judgment. Wait, I'm putting it in the judgment only.
I have purchased the land by registered deed, my lord.
Very well.
My lord, my question is this, my lord, that will be decided by the court below, my lord. In 227 petition, my lord, how that can be decided?
Better withdraw it.
Well,
Don't take that observation. Three days back, Supreme Court delivers a judgment. That is, I think, Rajiv Gupta. If I'm not wrong. What are you going to do? Withdraw. Dismiss only. Withdraw. I'll give that of you go and amend. Because you need to amend it. If you don't amend it, your suit is going to go. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner.
Let me withdraw, my lord. in that.
Withdraw.
Yeah.
Ekin Thakak.
Yeah.
And Mr. So-and-so who appears on behalf of the respondent. The instant application has been filed under Article 227 of the Constitution, challenging the order dated
6/8/24.
6/8/2024, passed in Miss Appeal number 11/2023 in 11/2023, whereby the order granting, refusing to grant any injunction dated 19/5/2023 passed by the learned Munsif number 1, Dorong and Mongoldoy in Midday case number 66/2019, arising out of title suit number 56/2019, was affirmed. Mr. M.A. submits that he would not like to, he has instruction not to proceed with the instant application. So considering the above, the instant petition stands rejected, stands closed on withdrawal. But you need to advise. Otherwise, your suit is going. You have a good case, but your case will go.
Regarding the statement declaration of title.
You have to put that, because in view of the recent judgment, I think it is Rajiv Gupta. There, the Supreme Court in the last 4 paragraphs dealt with that in a suit where a person is not in possession and seeks for the declaration, seeks for recovery of possession, but without a declaration, the suit is back.
Declaration of title. Section 34. Section 34 is specific relief manner.
Item 43.
Great pleasure. My lord, this, as per office note dated 14/5/2025, the service upon the respondent number 1, it says that, my lord, the address is not found. And regarding other respondents, my lord, we have taken steps and the ID card has not returned. There is some urgency because, my lord, suit is our suit. Plaintiff, this is petitioner's suit, my lord, where there is one stay order because, my lord, out of total 4 PWs, only 1 PW1 was cross-examined and others were not cross-examined, and their, my lord, order passed for dependent witness. During that period, 2019 to 2023, my lord, during COVID period, they could not come to the court.
Forget about notice, you don't have a case, we dismiss it. You are lucky to get a stay there.
But what happened, my lord? Only thing is.
Therefore, now I am asking the registry to give me all this, not the motion matters. So let the council have some satisfaction in it, notice. But again, come back with the next state, I'll be here. So here I am, so today it's
It's
dismissed.
up to your lordship, but what happened, my lord?
Absolutely no word.
And during that COVID period.
You should have further stated. Now in Hong Kong, there is some COVID business. So it is still continuing. 2023, where is COVID? The
No,
date
but-
on which he could not appear was
Earlier-
on 30. No, Mr.
Earlier
Council.
Police Council expired. in
I'm not
22.
concerned with that. 36/2023, there was no COVID.
Yes. There
On
was no
that
COVID.
very day, the person concerned had appeared. One witness was cross-examined, the other you did not file any petition.
No, my lord, what happened? The earlier council expired in 22 because of the COVID, my lord. And
So-
there-
How does it matter?
No, my lord, the file could not. be
This
traced out.
happened in 2023, June.
The file could not be traced out because they are, my lord,
How plaintiff witness number 1 was cross-examined
examined, my lord, he went to the.
without fail being placed out. Dismissal, how many dates you have taken? Oh, not much. Oh, long. 1 year it has been delayed.
It's our suit, my lord. We are the plaintiff. We
No,
are
but-
actually
What is the
otherwise
stage?
loser.
What is the stage of the suit?
Across a DW. It is fixed for DW. And, because they have already submitted their evidence on affidavit.
Hmm.
Only cross-examination, my lord, part is there. Let them cross-examine, face the cross-examination, my lord.
No. Can't help you.
Because, my lord,
Supreme Court can help you under 140. Not 222. 227 is too lesser power for this.
my
Alright,
lord,
Mr. Argusami, the learned counsel appearing on behalf of the petition. Full stop. The supervisory jurisdiction of this court has been invoked, challenging the order dated 11/7/2024, passed in title suit number 122/2013, whereby an application filed under order 18 Rule 17, read with section 151 of the Code of Civil Procedure, bearing petition number 1712/2023, was rejected. It is relevant to take note of that on 36, that it is relevant to take note of that the plaintiff, that the suit was fixed for evidence of the plaintiff on 17/9/2019. Full stop. The plaintiff adduced the filed evidence on affidavit, examination in chief of 4 witnesses, no?
yes,
4 witnesses, of which the plaintiff witness number 1 was cross-examined on 36/2023. And as the remaining witnesses did not appear on that day, the court proceeded to the next stage, that is, the filing of evidence of the defendant witnesses. Full stop. Subsequent thereto,
well, since the plaintiff number 1, PW1 was cross-examined on 36/23, my lord.
subsequent
Therefore-
thereto, the petitioner filed an application seeking recalling of the order dated 36/2023, and thereby for examination, for cross-examination of the examination of the plaintiff witnesses number 2, 3, and 4. First, this court have also taken note of the said application which has been filed under Order 18 Rule 17, read with Section 151. These petition, the said petition, requires judicial determination. And to the surprise of this court, the said petition is neither on affidavit nor there, is neither on affidavit, which is required under Order 6 Rules 15(4) of the Code of Civil Procedure 1908, nor is in compliance to Rule 15 of the Civil Rules and Orders framed by the Guwahati High Court. Gustav, this court have further taken account the reasons which have been assigned by the learned trial court and is of the opinion that the same do not fall for interference by exercising the supervisory jurisdiction of this court, for which the instant petition stands dismissed. Gustav, the interim order passed on 28/8/2024 by this court stands vacated. Gustav, the parties herein are the petitioner vacated, and the next date is fixed before the learned trial court on 16th of June 2025. Full taking into account that none of the other respondents have duly appeared, the learned trial court shall proceed with the suit by giving due notice to the said respondents who are the defendants in the suit.
Obliged.
Item 44.
Yeah, please, Lordship, here I'm challenging two numbers of order. Lordship may first page number.
Which order?
Page number 32. So here in this case, at the stage of argument, the document was allowed to be introduced. Disputing the fact that at the stage of argument, a document cannot be introduced. I'm only on the question of due diligence on the part of the respondent. Because
Is it mentioned about the sale deeds in his written statement?
the deed number is not mentioned. They have stated they have, the land was sold to Dilip Mura in 2009, but the sale deed was not mentioned. So the written statement was filed in April 2013. Trial concluded, it was fixed for argument. Then they filed the application in 2019.
You are a plaintiff?
Plaintiff.
Yes, madam.
My lord, in the order sheet, it is clearly written that for determination of real issue, my lord, that document is necessary. And my lord, and one more thing, my lord, that document kindly say annexure 7, page 39. It is already, my lord, allowed in 2019. That's why our court has, my lord. Annexure 7, page 39. Last page, my lord. Already petition number 252/21 is allowed by the order dated 31/8/2023 on the ground that said document is necessary for proper adjudication of the case.
Now, tell me one thing. You got this copy on 15/11/2019. Okay. Now, why did you file it in the year 2021?
My lord, at that time.
And in the meantime, did you adduce evidence? Must have.
Not evidence, because it was fixed for argument in 2019.
Then why?
Then because of this Corona 20.
But this order is passed in 2023. They filed the petition in 2021.
24/1/22.
24/1.
24/1/22.
And then the matter has been pending from then. Which court is this?
Munsif number 2.
What is wrong with the judge? Now, if they bring this document, means the defendant has to be given a chance to adduce evidence. You can't bring in the document so that they have a right to cross-examine on the document. What is this type of orders being passed? This then permission means you have to adduce evidence. How does the court say? The court cannot say they bring only on record the certified copy, isn't it? So the permission under 151 is for additional evidence. Additional evidence is being permitted. Okay. But you have to adduce evidence and then they have a right to cross-examine on the document, isn't it?
Because they have the knowledge of the document. It's not a new document, they do not have the knowledge.
Hmm?
They have the knowledge of the document.
They say that it was not found earlier. They didn't mention anything. Because these documents having not been earlier relied upon, this could not have been done in
Yes.
this manner. Does it take 2 years?
There is foundation of existence of the cell deed in the plain. That's why court has allowed.
Where?
The deed number is not mentioned. Page number 19. Last bottom.
What is the sale deed dated?
25/10/2009.
Huh?
25/10/2009.
2510.
2009.
Now, what is this at page 20? Last paragraph. That Dilip Mura, son of so-and-so, was possessing the suit land and so-and-so as owner of the possessor and recorded patta, and there was a contract for selling of the same in favor of the defendant number 5 and was fixed as Iman and Iman, and he applied for sale permission. Permission was granted by Iman and ultimately the defendant purchased the suit land from his vendor, Dilip Mura, by a consideration a year through execution of a registered sale deed number 986/12, dated so and the said year delivered possession of year to defendant number 5 has been possession. Is this the sale deed?
Not lordship. This is the subsequent sale deed. They want to show that their seller has a, sorry, the vendor has a valid title.
Okay, Nirmal Nath sold to Dilip Mura.
Yes, lordship. And Nirmal Nath also sold to us.
But have they mentioned anything in any of the evidence also? Because the trial court does not look into that aspect also.
Yes, Lord.
Peruse the preferred at the stage of argument, the plaintiff filed the instant. And also transpires that at the stage of the plaintiff side filed. You are the
No.
defendant.
I'm the plaintiff. It has been wrongly recorded, Lord. The
Okay.
defendant.
Also, the defendant had not taken the plea in the written statement that the Iman, the registered seal by which the Iman sold the land to Iman is not traceable, for which they will adduce secondary evidence. But the learned Yeah, and I've taken a finger with this paper. Now, the judgment which is being referred to, a party to a lease may choose to file an application which is required to be considered by the trial court, but if any party to the suit has laid foundation of leading secondary either in the plaint or evidence, the secondary evidence cannot be ousted. I think we need to modify this order, by which they cannot just produce the certified copy. This order is wrong. You cannot produce you have to produce evidence. And you will have a right as regards cross-examination, even on the aspect of secondary evidence. Heard Mr. G. Bhardwaj, the learned counsel appearing on behalf of the petitioner, Ms. So-and-so, who appears on behalf of the respondent. This is an application, the present application has been filed by invoking the supervisory jurisdiction of the court to challenge the order dated 31/8/2023, passed in title suit number 153/2012 in connection with petition number 252/21 filed under section 151 of the Code of Civil Procedure 1908, for short the code, whereby the learned trial court have allowed the said application. Trial court नाम तो दिसू है, whereby the learned court of the civil judge, junior division number 2, Nagaon, hereinafter referred to as the learned trial court, have allowed the said application. Full stop. It is relevant to take note of that the said application was filed at the stage of arguments. Full stop. Both the parties duly admit that the suit was fixed for arguments in the year 2019. Thereupon, in the year on 24/1/2021,
22,
21,
24/1/2022.
they filed this application. By why the petition is numbered at 252/21?
That has been wrongly numbered.
That is also wrong.
Yes.
On thereafter on 24/1, 24/1/2022, the petitioners, the defendants in the suit, defendant number 5 in the
Defendant.
suit, who is the respondent number,
Sole respondent. Sole respondent.
the sole respondent herein, filed an application under section 151 to adduce additional evidence by bringing on record a registered sale deed number 4282/19, which the defendant number 5 states that the same could be the knowledge of the said deed of sale, the number of the said deed of sale could be ascertained only on 15/11/2019. Could only be ascertained on 15/10/2019. And the certified copy was obtained thereafter and the counsel who represented the defendant number 5 was instructed on 15/11/2019 to file a petition seeking granting of leave. This court duly takes note of that the learned trial court on 31/8/2023 disposed of the said application by permitting the defendant number 5 to adduce the certified copy. They were permitting the defendant number 5 to file the certified copy of the registered deed of sale bearing deed number 4282/19
Actually, 2009, 4282 of 2009. Here it
oblique
is-
19.
It is wrongly recorded, wrongly mentioned in the order. 2009, the deed is of the year 2009,
Oh, no, 09,
09.
not 19, 09. 09 को 4282/09. Full stop. Being aggrieved, the present proceedings have been initiated. This court have duly heard the learned counsels appearing on behalf of both the parties and given an anxious consideration to the matter. Full stop. At the outset, this court finds it relevant to take note of that the learned trial court, that it surprises this court that when a petition was filed under section 151 on 24/1/2022, how such an decision on a such application would have been as to how there is so much of delay in disposal of such an application. First, next, in the application, in as much as the order was passed on 31/8/2023. More than 17 months, 17? 19 months.
19 months.
19 months from the date of filing of the said application. Full stop. This court further takes note of the written statement wherein there is a mention about the sale being made by one Nirmal Nath in favor of Dilip Mura. Full stop. However, there is no foundation laid in the plaint, in the written statement, or even in the application so filed under section 151 as to why the certified copy is required to be, why the original could not be produced and permission should be accorded for adducing secondary evidence. It further surprises this court that the learned court below, the learned trial court had fixed the matter for filing the certified copy of the sale deed, but without taking into consideration that this certified copy cannot be adduced in such a manner. It has to be adduced by adducing further evidence by the defendant witness, through a defendant witness. First, be that as it may, taking into account that the learned trial court is of the opinion that the said document would be essential for a just decision in the suit, this court would not like to interfere with the discretion so exercised in permitting to adduce additional evidence. However, this court observes that the adducing of the additional evidence of the deed of sale that has to be in the manner envisaged in the law, that is by way of a person, by way of a defender, by way of a witness. Full stop. Further to that, the plaintiffs would also have a right to cross-examine the witness, not only on the veracity of the said certified copy, but also on the question as to whether the certified copy and also would not only be entitled to raise would have a right to cross-examine on the veracity of the said deed of sale, as well as also put under objection the said deed of sale being a secondary evidence. And this court further observes that in such a circumstance, if the deed of sale is put under objection, the learned trial court, while appreciating the evidence of the said deed of sale, shall do so without being influenced by the order dated 31/8/2023. Full stop. With the above, the instant proceeding stands disposed of. Full stop. The interim order passed by this court on 8/11/2024 stands vacated, and the parties who are duly represented are directed to appear before the learned trial court on 11th of June 2025, on which date the defendant number 5, on which date the defendant number 5 shall file the examination on chief of the additional examination on chief of a witness, along with the said deed of registered deed, along with the deed of sale, certified copy of the deed of sale. Ipso by full stop. It is observed that if the said evidence on affidavit examination in chief is not filed, the court can proceed with the disposal of this.
For orders item 11.
It's not dated 18/2/2025, my LCA has been received, my
LCR received, service complete.
Yes, sir.
What case is this?
The case for enhancement.
Enhancement?
Fine.
You have a right?
File,
Good case?
file.
Let's allow it. Allow it.
Not today, Lord. I'm not ready today.
Huh?
I'm not ready today. I missed
You are not ready today.
any day, any day.
How much you got?
My lord, only 2,40,000, my lord.
For what happened? You died?
No, my lord, 40% personal disability. my
Huh?
lord. 40% personal disability.
40%?
40%, my lord.
How much you say that you are entitled to?
My lord, petitioner has claimed for 14 lakhs, my lord. And my lord, honorable court has recorded, my lord, the expenditure of medicals, my lord, is 1,66,000, my lord. And he has paid, my lord, 15 million.
2013 matter, Mr. Goswami. If we delay the matter, this 14 lakhs will be over exceed.
Not just one day. I missed the file.
Huh? My intention is to finish up one matter to this type of appeals in a day.
Just one day.
The LCR having been received, this matter for hearing on when?
18/2/2025, my lord.
What?
18/2/2025. As for office not there. 18/2, my lord.
18 to
25.
why? Why? No, I don't know why. Hearing when? On 4th of June 2025 at 2 p.m. If I'm sitting, I'll finish it.
Problem, sir.
12.
Who is there for the other side? Oh, Mr. Goswami, you are there. What is your case? You are ready with this?
Lordship, Lordship, this matter may come for hearing after local because I have been approached by the insurance company to, it in fact, yeah. If the date may fix after 14 June, if it doesn't get settled, it will be a.
Lordship, the awarded amount has already been deposited.
Huh?
Awarded amount in death case, Lordship, minor death case.
Deposited and
Lordship, the award was 5 lakhs and with interest 6 lakhs 2,000 has been deposited. Yes, Lordship.
Deposit
And
after
we have
50% has been released.
we have put down 3 lakhs, Lordship. If the entire amount is given to us, then the case may be closed, Lordship. Minor
What
death
happened?
case-
Somebody died?
Yes, Lordship.
Accident took place due to the death of a offending
Criminal
vehicle.
prosecutor-
From the
5-year-old
claimant,
boy.
man. What is your ground?
He was
We had
just
seen the
5.
materials and the deceased was a minor child of 5 years, hence was a non-earning notional income as per EI is 15,000 as per the second schedule.
Claim of 2012, at that time for a 5-year-old, it was.
It 50,000. Yes. No case. You are only helping Mr. A.R. Agarwal. And 9% interest is going on. You have deposited, the entire amount has been deposited, no? So he's not getting any benefit. Take the money.
Yes, Lordship, with 3 lakhs we have released, Lordship.
No, there's no question of making any further payment.
Yes, Lordship.
No, there's nothing, we finish it off. 5 minutes, I'll finish it off. Heard Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner, appellant, and Mr. A.R. Agarwal, the learned counsel who appears on behalf of the respondent number,
One Clement,
respondent number 1 and 2.
Clement.
Pustup. It is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 27/6/2014 passed by the learned member MACT Dhubri in MAC case number 161/2012, filed under section 166 of the Motor Vehicles Act 1988. Pustup. It is seen that the learned tribunal had awarded an amount of rupees 5 lakhs had awarded an amount of rupees 5 lakhs along with interest at the rate of 9% per annum from the date of filing of the claim petition, that is on 14/9/2012, till actual realization. It is relevant to take note of the grounds of objection which have been taken by the appellant. Mr. R. Goswami, appearing on behalf of the appellant, has submitted that the amount which have been adjudged in the instant proceeding is on a higher side. And it would not come within the ambit of a just and fair compensation in terms with section 168 of the Motor Vehicles Act 1988. This court have duly taken note of the impugned judgment, as well as this court have duly taken note of the materials on record, as well as the impugned judgment passed by the tribunal. And from the materials on record, it is clear that the 5-year-old child expired on account of the rash and negligent driving of the vehicle, being vehicle number AP 16TB/6498, and the vehicle was duly insured with the appellant insurance company. Full stop. This court further takes note of that the defendants have, that the claimants have duly produced the evidence as regards the rash and negligent driving. And in that regard, the learned trial court tribunal was justified in coming to a finding in respect to the issue number 1 and 2. In respect to the issue number 3 and 4, the learned tribunal have relied upon the judgment of the Supreme Court in the case of Kishan Gopal and another versus Lala, what is that? Lalchand?
Lala.
Lala and others, Supra. What is the citation? Reported in Silo, Kubat? Wherein the Supreme Court had observed have duly taken note of the judgment of the Supreme Court in the case of so and so, and the application of the said law by the learned tribunal, which led to the findings arrived at as regards the just and fair compensation. The compensation so awarded of rupees 5 lakh do not seem to be on a higher side. Accordingly, this court finds no ground to interfere with the impugned judgment and award dated 27/6/2014, passed in MAC case number 161/2012. Next, it has been also brought to the attention of this court that at the time of admission of the entire appeal, the amount of rupees 5 lakhs along with the interest accrued thereon have already been deposited before the registry of this court, isn't it? Full stop. Mr. A.R. Agarwal submits that 50% of the said amount have already been released to the
Not exact 50%, 3 lakhs has been.
3 lakhs have been released out of the said amount which have been deposited. Considering the above, this court further directs the registry to release the remaining amount.
Oh, 3 lakhs, 2,039 rupees.
3 lakhs, that is
2,000.
rupees 3 lakhs
2,039 rupees.
and 39 rupees to the claimants upon proper verification, identification, as well as upon furnishing the bank details. First of all, it is made clear that the appellant insurance, the registry shall only transfer the amount through bank to the bank account of the claimant.
Yes, what has happened in this case? Well, the petitioner herein is the defendant in the suit.
Which order you are challenging?
Well, the order that is at page, starts at 69.
Huh?
Page 69. Well, the composite order under order 9, rule 9 and order 9, rule 13 was allowed.
You
Filed by
challenge this 5/11/2019
19,
in 2022.
my lord.
What?
My lord, because in the meantime, their application under order 9, rule 9 was dismissed for default. When the enhancement of jurisdiction, though it has allowed in deciding order 9, rule
I'm not
13.
on that, but how are you challenging an order of 5/11/2019 in
Madam.
2022?
My lord, there was some kind of delay.
On that ground only your petition should be dismissed. Isn't it?
Well, only thing is this, my lord, that
Your application on the order 9 rule 13 was allowed.
Lordship, their basic contention is a contested inter-party suit. So that's why their basic contention in this memo is that it's a contested order. Therefore, order 913 or order 929 is not attractive. Lordship has already decided this issue 2022 judgment.
Order 17
What
rule
you-
two.
what I didn't do?
Well, order 17 rule two,
Lordship,
after
that
76
is,
amendment, it is
It
not ex parte, it is intra party, I admit, my lord. My only issue before your lordship is this. While deciding order 9 rule 13, when their prayer was setting aside of a decree in a counterclaim, and a separate application for order 9 rule 9 was there. While deciding 13, order 9 rule 13, he has disposed of order 9 rule 9 when the application was separately pending, and on enhancement of jurisdiction, when that application went down, that application was dismissed for default. That order still survived, and they have not challenged that order. So order 9 rule 9 application was still surviving, which is dismissed for default. Their suit was dismissed for default. And when I see the prayer in that order 9 rule 13, there is no such prayer as such.
What the trial, what has happened is, on 5/8/2016, the suit was dismissed and the counterclaim was proceeded with. Counterclaim was decreed on 14/7/2017. The petitioner thereafter, the respondent hearing, who is the plaintiff I suppose, filed two applications. One was an application for restoration and the other was an application for
Setting aside,
what do you
setting
call it?
aside the decree.
Setting aside the decree. Both were allowed.
My lord, both were allowed on a pretext that the Order 9 Rule 13 application contains both the prayers, which is as not such.
No.
My lord, here in para 23, your lordship will find in the judgment. Para 23 of the judgment. In the application 180517, there are two prayers. One is for setting aside the judgment and not decree passing counterclaim, and also restoration of title suit for setting aside the order dated which the said suit was dismissed. Para 23.
Then,
My lord, if I look into the prayer of Order 9 Rule 13, there was no such as prayer for restoration of the suit. That is why they have filed a separate application. Now, on enhancement of jurisdiction, the suit came below in the Municipal Court.
no, understood. Separate application was filed along with that application.
My lord, separate applications, separate.
Let us not go into technicality. If we go into technicality, we go further into technicalities with you.
My lord,
Why have you filed it after 3 years?
my lord, as on today, that Order 9 Rule 9 has been dismissed for default.
It can't be dismissed for default after this order has been passed.
Because,
Whereby,
my lord,
forget about Order 9 Rule 9, because that is absolutely not necessary, taking into account that the order, by this order on the 5/11/2019, the order of 5/8/2016 has been recalled.
my lord, that, but my lord, as on that day, because my lord, there was no such prayer in that application. No
Not
such,
there, but the court had made the mistake in not saying that there was a separate application. Because of the court mistake, should the people suffer?
but my lord, what will happen to that application if it is dismissed for default?
That has been wrongly dismissed for default. It's a non-est
that
application.
was
The
dismissed for
the
default
order
because of-
passing that it has been dismissed for default when that application has been allowed.
My lord, because
The
there,
prayer of the application was allowed.
because the court held that Order 9 Rule 9, the application was pending because without there being any process to that. There was no process was served to the other side. That is why it was dismissed for default.
What process?
Because my lord, when it was pending in that Order 9, no steps were taken in that Order 9 Rule 9 application. And so that was dismissed for default,
What
without
steps?
serving the process.
Were you not aware of you let us see your objection file?
My lord, objection as regards 134, that is at page 61.
Kindly see the prayer in Order 9 Rule 9.
My lord,
By condoning the delay, issue notice to the so and so and please to set aside the judgment and order, the impugned order and the judgment in decree.
but
The suit be revived and restored to the file. Allow the AR to take part in the proceedings and heard on truth on me. This
your
is
lordship,
prayer.
your lordship is saying in Order 9 Rule 9. But that Order 9 was kept pending. It was not disposed of. It was not
No,
disposed of.
no, this is Order 9 Rule 13.
13, my lord, yes, Order 9 Rule 13, the prayer is
Yeah.
the respondent counterclaim and be pleased to set aside the impugned order of the counterclaim. And the judgment and decree and the suit be revived and restore the file, they allow the petitioner to take
No,
part in the
no.
proceedings.
See, be pleased to set aside the impugned order and the judgment and decree.
And be revived and restored.
And the suit be revived. There is there. It's a composite application.
But my lord, there is admitted fact, there is an application for Order 9 Rule.
They must have taken more money from the client, the lawyer, and filed another one. That doesn't make sense.
My lord, at least in the rest, allowing the counterclaim, there should be a fault also, there is nothing as such. And my lord, lot of allegations are there against the advocate. Neither there was a application before the bar council, neither he was called upon, neither he was made a party, nothing of that sort. And all allegations is against the advocate.
But why did you file after 3 years? And without any explanation? Let us also go into technicality.
It's better to fight the matter on merit, my lord. Technically, will not play a bigger role, my lord.
But my
It
instruction
lord, it
was
is their case
the
that,
decree was executed, my lord. After that it was set aside. The decree was executed, thereafter it was set aside. And it was executed. Decree was,
So
executed,
then the question will come for restitution.
my lord. They have not filed an application for restitution,
Should I give him the liberty?
my lord. Without a prayer, my lord. Lord, at least ordinary rule 13 demands some kind of a cost, my lord. They have not given any cost.
Cost 25,000. 25,000 cost is minimum.
only,
Because
it
you
is a
filed
prayer,
it.
my lord. Is a village lady, my lord, no source of income, lordship, if possible to.
Heard Mr. P.K. Rochaudhary, the learned counsel, is appearing on behalf of the petitioner, and Extend Substitute, the learned counsel who appears on behalf of the respondent number
My lord, I am representing respondent number 1
1.
and 2.
Who is the plaintiff?
My lord, Sri Swarnalipi Bora. Srimati Swarnalipi Bora.
So you are appearing for 1. And who are the other respondents?
The-
I am for 3. I'm the dependent number. Dependents, we are not concerned.
I am the principal, my lord.
Respondent number 1 and Mr. S. Count, who appears on behalf of the respondent number 3. The supervisory jurisdiction of the spot, supervisory? Supervisory.
My lord, my lord, my lord, my lord, my lord. Because there is no provision for appeal, if it is allowed. Only if it is dismissed, then my lord, appeal lies. In the CPC, what I, subject to correction, my lord. What I find, my lord, appeal only lies if it is dismissed. If it is allowed, there is no provision for appeal.
The supervisory jurisdiction of this court has been invoked challenging an order dated 5/11/2019 passed in Mize case number 134/2017 arising out of title suit number 22/2023 by the Court of the Learned Civil Judge Nagaon. Civil Judge Nagaon, whereby the application filed under Order 9, Rule 13, with the composite prayer of restoring the suit by setting aside the order dated 5/8/2016 was allowed. For setting aside the judgment and decree dated 14/7/2017, along with the composite prayer for restoring of the suit, which was dismissed for default on 5/8/2016 was allowed. At the outset, this court finds it very pertinent to take note of that although the provisions are, although there is no limitation prescribed for filing an application under Article 2 to 7 of the Constitution. But it shocks and surprises this court that an order which has been passed on 5/11/2019 was put to challenge by the impugn order which was passed on 5/11/2019 was put to challenge on by filing the present proceedings on 23/11/2022. That too without assigning any reasons. On this ground alone, the instant application filed under Article 2 to 7 of the Constitution ought to be dismissed on the ground of laches. Be that as it may, taking into account the points, the grounds urged by the learned counsels appearing on behalf of the parties, this court finds it relevant to take note of the facts which led to the filing of the instant application. The respondent number 1 had filed a suit Where is the suit? That is also not
They
there.
have not enclosed, my lord, I have the copy, right title interest, my lord,
Right title interest.
this is the copy.
I filed a suit claiming, give me a copy of the plaint.
Yes,
I think no cost.
not, I write title interest, my lord.
No cost in this case. Cost is also not there.
Yes.
This type of filing. I filed a suit seeking a decree for declaration of right title and interest of the plaintiff over the suit land for permanent injunction against the defendant for cancellation of the mutation recorded in favor of the defendants in respect to the suit patta, as well as for a decree for declaration that in the event of introduction of or discovery of fraud deed of conveyance or any other documents relating to the alleged transfer of the suit land, in course of the trial, the same be declared as illegal, ultra vires, and consequently, no right could have been confirmed on the basis of such illegal document, etc. In the said suit, which was registered and numbered as title suit number 22/2013, the respondent, the petitioner herein, the petitioner herein, who was the defendant number,
Number, my lord, in the suit.
who was the
Magiram Das.
Maghiram is who? Maghiram.
My lord,
Defendant number three.
respondent number
Defendant number 3
three, my lord.
had filed a written statement along with the counterclaim. Full stop. In the counterclaim, the defendant number 3 prayed for a decree declaring his right title and interest over the claimed land described in the schedule to the said counterclaim, and for recovery of possession. Full stop. The materials and records reveals that the suit was dismissed for default on 5/8/2016 on the ground that the plaintiff, in spite of being given due opportunity to file the evidence on affidavit, examining the evidence, failed to do so. And the preliminary trial court further proceeded with the suit proceedings for the purpose of deciding the counterclaim. The counterclaim was decreed by the judgment and decree dated 14/7/2000. You are the defendant number 3. I'm the defendant 2. The learned trial court further proceeded with the suit, and by the judgment and decree dated 14/7/2017, the suit was decreed in favor of the defendant number 3, who is the petitioner herein. Pursuant thereto, the plaintiff filed 3 applications on 20/10/2017 before the learned court of the civil judge, Nagaon, before the learned trial court. One was an application under Order 9 Rule 9 for setting aside of the order of dismissal of the suit for default on 5/8/2016, which was registered and numbered as Mizze case number 133/2017, The second application was an application filed under section Order 9, Rule 13 for setting aside the judgment and decree dated 14/7/2017 in counterclaim. In the counterclaim, which was registered and numbered as Ms. J case number 134/2017. Third application was an application under section 5 explaining the delay in filing the applications. And for condoning the said delay. No authority, the respondent number 3, the petitioner who was the defendant number 3, opposed the applications by filing a written objection in the proceedings under Order 9, Rule 13, as would appear from Annexure 8 to the present proceedings. Thereupon, the learned trial court passed the order on 5/11/2019. When was the delay condoned?
My lord, on the same application.
But in the same application,
Same
Ah.
day 69.
And thereupon, on 5/11/2019, the impugned order was passed whereby not only whereby the order dated 5/8/2016 by which the suit was dismissed for default was recalled and the suit was restored to the file of the court, semicolon. The application for setting aside the decree, judgment and decree passed in the counterclaim dated 14/7/2020. The judgment and decree application, the judgment and decree dated 14/7/2017 passed in the counterclaim was set aside, as well as the delay was condoned. It is under such circumstances the present proceedings have been filed. Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, has drawn the attention of this court that the learned trial court erred in law in restoring the suit to the file without passing an order in Ms. J case number 133/2017. And the learned trial court further allowed the prayer made in Ms. J case number 133/2017 in the decision so rendered in Ms. J case number 134/2017. He further submitted that although the learned trial court by the order dated 5/11/2019 recalled the order dated 5/8/2016, but taking into account that Ms. J case number 113/2017 was not, no order was passed, and subsequently the suit was transferred to the court of the civil judge number
Junior division number 2.
Number 2, Kamrup Metro,
No,
Nagaon. On account of the amendment to the, on account of the change in the pecuniary jurisdiction in view of the amendment to the Assam, Bengal, Assam, Agra Civil Courts Act 1887. The said application being Ms. J case number 133/2017 have been dismissed for default. He therefore submitted that in view of that order by which Ms. J case number 133/2017 was dismissed for default, comma, the suit cannot be proceeded with. Isn't it? That's your submission. On the other hand, Mr. S. Samaria, the learned counsel appearing on behalf of the respondent number one, who is the plaintiff, submitted that that though two applications were filed separately under Order 9, Rule 9, as well as Order 9, Rule 13, but the learned trial court, by the impugned order dated 5/11/2019, had allowed both the applications as would be seen from a perusal of the impugned order dated 5/11/2019 itself. He therefore submitted that this is not a fit case wherein this court would exercise its supervisory jurisdiction, inasmuch as what the learned trial court had done was was in the interest of justice, and by duly assigning reasons, but not in the mode which ought to have been expected. Anything more? I've heard Mr. Khan, anything? Mr. S. Khan, appearing on behalf of the respondent number two or three?
For respondent
Three. With the defendant number? Two. Submits that the said defendant number two did not object to the petition so filed by the petitioner. No, you did not oppose. Have not opposed the applications so filed by the plaintiff on the ground that the land of the defendant number two from the suit pata. This court have heard the learned counsels appearing on behalf of the parties and have given in its anxious consideration. A perusal of the impugned order dated 5/11/2019 clearly shows that the learned trial court had dealt with both the prayers for setting aside the order dated 5/8/2016, as well as the application, as well as the judgment and decree dated 14/7/2017. The learned trial court further, upon hearing both the sides, have adduced due reasons for allowing the application for condonation of delay, as well as both the applications, as well as for setting aside the order dated 5/8/2016 and the judgment and decree dated 14/7/2017. It is to notice that the learned trial court ought to have passed the order in respect to setting aside of the order dated 5/8/2016 in Ms. case number 133/2017. But the learned trial court have done so in a composite manner. But the learned trial court in a composite manner have challenged, have interfered with both the orders dated, the order dated 5/8/2016 and the judgment and decree dated 14/7/2017. This court further takes note of the reasons which have been assigned and the manner in which the learned trial court have exercised its jurisdiction. The exercise of the jurisdiction which have been done, it is the opinion of this court that it is not the case that the learned trial court did not have the jurisdiction to pass the order. It is only the question of that the learned trial court would have been, the learned trial court was required to pass the order in Ms. case number 133/2017. Full stop. This aspect of the matter does not shock the conscience of this court to exercise its supervisory jurisdiction. On this ground, this court finds no ground for interfering with the impugned order dated 5/11/2019 passed in Ms. case number 134/2017. Be that as it may, this court, however, finds it very pertinent to take note of that these applications were filed in the year 2017. Well, filed in 2017, not much of delay. Was filed in the year 2017, and be that as it may, this court finds it relevant to observe that the learned trial court ought to have imposed certain costs in view of the fact that there was certain delay in view of the fact that there was certain delay caused in the disposal of the suit as well as the injunction as well as the counterclaim on account of the fault of the plaintiff. And in view of the order dated 5/11/2019, the said proceedings would again revive. So considering the above, this court is of the opinion and that a cost of rupees 25,000 ought to have been imposed by the learned trial court in that regard. So considering the above, this court therefore disposes of the instant proceedings with the following observations and directions. Number one, this court is not interfering with the order dated 5/11/2019 in Ms. case passed in Ms. case number 134/2017, arising out of title suit number 22/2013. Number two, the order dated 5/11/2019 passed in Ms. case number 134/2017 shall also be construed to be an order passed in Ms. case number 133/2017. Number three, in view of the opinion of this court, or opinion and observations of this court in the clause 2 herein above, comma, the dismissal of the said application being Ms. case number 133/2017 by the learned court of the civil judge junior division number 2, Nagaon is held to be non-est. Number three, this court further imposes a cost of rupees 25,000 upon the plaintiff, which has to be deposited before the learned trial court on the next date so fixed herein above, herein after. This court further takes note of that by an order dated 16/12/2022, the further proceedings of title suit number 22/2013. 16/12/2022, the order dated 5/11/2019, passed in Ms. case number 134/2017 was stayed. Full stop. The said stay order is vacated. Full stop. It is also brought to the notice of this court that in view of the stay order so passed by this court, the further proceedings of title suit number 22/2013 as well as the counterclaim could not be proceeded. Under such circumstances, this court fixes 16th of June 2025 for appearance of both the parties before the learned trial court. That is the court of the learned civil judge, junior division number 2, Kamrup at Nagaon. The learned trial court shall thereupon proceed with the suit from the stage of the stage of the order dated 5/8/2016.
Order item 13.
Service not completed or none. Who are you? None appears for the appellant. Okay.
And for respond number 3, Lordship.
What is this matter about?
Lordship, it's a motor accident claim cases, Lordship. It's against dismissal. This is filed against dismissal. Lordship.
Do they have a
Case of
case? madam?
2011, Lordship.
Huh?
2011, it's an MSCP case of.
Why it was
2011.
dismissed?
It was dismissed, Lordship, because they failed to prove the evidence. They failed to produce evidence because they took time everything. It's a
None
case of
appears on behalf of the appellant on call. Full stop. It is also seen that on the earlier occasion also, the appellant is not represented. Considering the above, this court appears that the appellant is not interested in the present proceedings for which the appeal stands dismissed for non-prosecution.
Must oblige, Lordship.
Ms. M. Chaudhary appears for the opposite respondent number 3.
14.
What is this?
My lord, in this matter, the analogous matters were disposed of. But as per office note dated 16/5/25, only MSC appeal 3 of 24 and 266 of 10 with LCR has been found out and tagged with this appeal. And other cases cannot be traced out at present, my lord.
What are you challenging?
Lordship, there are 6 analogous appeals against the same accident. 5 has already been disposed of. We could look at the judgments of 4, dismissing the appeals of the insurance company.
Oh,
This is a covered judgment. Their plea has been rejected in earlier 4 cases.
why these are analogous?
Same accident, Lordship. There are 6 appeals for the same accident. And out of this. as
Why
per our
are they
record, we could look at
challenging? Why are you challenging, madam?
My lord, to be very honest, I could not trace out the file also, and my senior is also out of station. Kindly, we have 1 week time may be granted, my lord.
So, who is your senior?
Issue Dr. Sir, my lord. Kindly 1 week time may be granted.
Number 2. If your senior was then, when the appeals were admitted, I would have.
My lord,
But he has become a senior advocate by then.
my
Can't
lord,
help you.
so that I pray that we have to take instruction also from the insurance company.
What is the service required?
As per the last order, service is complete, my lord.
Service completed, Lordship. And the last order in 17, it was on 9/1/17. For taking up all the 6 appeals together. But to our hard luck, our appeal was left out.
Which one?
This 3/17.
3 is there, another one is MSC 266. MSC
266
266
our
is
causeless
disposed of.
clause is disposed of, but we could not locate that order.
MSC 266 is disposed of.
No, as per cause list, but we could not locate the order.
Hello. What is the challenge you don't know? Anyways, you see, is this matter for final disposal on 30/5/2025, 2 p.m.
Oblige.
All give your names. I'll be putting it in glittering in the.
Item 15.
Your lordship. Here, your lordship, MSc appeal, your lordship, against
judgment and award dated 3/5/2013, which has been passed by the learned member MSCT Kamrup in the MSC case number 18-8.
What is this
Yeah.
IA for?
Lordship, they have given one affidavit, your lordship, claiming that whatever enhancement has been given, your lordship, they already paid it. But here, the calculation part, your lordship, I would like to draw your attention towards the petition in page 20 of MSC number 3440 of the 2018. Your lordship, paragraph 5. I would like to draw your attention. May I read, your lordship?
Has the appeal been disposed of?
Earlier, your lordship, MSC appeal number 284, 2013. Here, your lordship, which I have already annexed it as annexure A, page 26 onwards, your lordship. The operative portion, your lordship, 27 onwards, it was.
Now what has happened?
Your lordship, the last operative portion, your lordship, that is paragraph 13, which is in page
So your
34.
basic case is that amount has
And
not been given
enhancement amount-
to you as per what it is.
Yes, your lordship,
calculation.
only 1 lakh annexure B, I have already annexed it, page 36. Apart from 10 lakhs, your lordship, only 1,63,000.
Why are you before this court? Award has been passed by this court. Go there before the tribunal. This court has no business to look into this. The
Your
court
lordship-
has, are you asking this court to change the judgment?
No, your lordship.
So therefore you go before the tribunal if you are not aggrieved.
Your lordship, apart from that, your lordship, MSC appeal, your lordship, which has been, your lordship, that was filed in Honorable Guwahati High Court itself, your lordship, which has already annexed it as annexure A.
Madam, are you saying that this court would be the executing court?
Already, your lordship, pertaining to that appeal, your lordship, already order has been passed, your lordship.
Madam, first of all, you have to know which are the three rungs in which proceedings happen. A tribunal passes an order. That is the executing court. It gives you a claim compensation as it may be so. If the compensation is not paid, you file an execution proceedings. There it goes. The first appeal comes before this court. This court may modify, allow, or extend, or may dismiss your appeal. Here is the case where the court modified the decree and said the award and said that he will be instead of 16 or 19 lakhs, 34 lakhs he will be entitled to along with interest. Thereupon, whether they went to the Supreme Court, I don't know. So now, therefore, the question is, you are entitled to these 34 lakhs along with interest, whatever may be. It may be 60 or 70 lakhs, I'm not concerned to the effect. What you are entitled to is to be executed before the tribunal. Veterans, isn't it?
Lordship, although amount is enhanced only to 50,000, Lordship. So as the victim was driving a vehicle, our liability is only 50%. 50% is deducted. So only 50,000 is increased from what is awarded. Lordship.
Isn't it to be decided in the executing tribunal, before the tribunal?
No.
Or does this court become the executing?
We have filed affidavit that we have paid every amount.
You
Lordship.
have paid or not paid. Does this court have the jurisdiction? Tell me. Nobody is challenging the order.
Yes.
The order remains like this.
Yes, Lordship.
Just for example, this matter tomorrow goes to the Supreme Court and the Supreme Court enhancing it by another 10 lakhs. I go into the Supreme Court and say that, oh, he has not paid this. It is for the tribunal to look into it. If it has not been paid, how the tribunal will take it up? What you want to file, you may file against that under the Insurance Regulatory that Act is there. Go ahead, file against them, make them whatever maybe you feel like doing. But this is not an IA file.
IA has not filed by me, your lordship. They have filed that IA, your lordship.
Unusiam and
No,
others.
we
Who
have
has
not
filed?
filed. We are respondent in the.
You have filed it.
Filed by other claimant. Claimant has filed. The appellant has
Who is Ms. P. Das?
I-
Then your name glaringly appears. Forgot who has filed it.
Affidavit in opposition.
The Hope
Affidavit in opposition, your lordship.
heard Miss so-and-so appearing on behalf of the applicant. And Mr. AJ Saikia, who appears on behalf of the respondent insurance company.
Yes.
Respondent number?
One.
Respondent number 1. Full stop. This is an application filed under
Lordship,
section 151 of the Code of Civil Procedure,
lordship,
seeking a direction upon the respondent opposite party, upon the respondent number 1, to make calculation as directed in paragraph number 13 and 14 of the judgment dated 9/4/2018 passed by this court in MAC appeal number 284/2013. Full stop. This court is of the opinion that when the judgment and award has been passed by this court, whereby there is certain enhancement to the award, the petitioner, the applicant herein, if so agreed, has to take resort to a proceedings before the tribunal for the purpose of enforcing the said award and not file an application under section 151 of the code before this court. Consequently, this court finds no merit in the finds the instant application not maintainable, for which the application stands closed. So the closing of the application, however, shall not affect, prejudice the rights of the applicant to approach the learned tribunal.
deeply obliged.
16,
Is this?
My lord,
What are you doing with
I
MACP?
concern, my lord.
Huh?
Regarding substitution, my lord.
Who died?
My lord, the main claimant died, my lord. They are a legal hire, my lord, four in numbers. Earlier, there was a delay in preparing the IML that has been condoned. That is, my lord, 3505/2018, my lord, that has been condoned.
35?
3505/2018, by order dated 1/9/2023, the delay of condoned.
What are the others?
Others, my lord, 3506 is the, my lord, substitution. 3507 is the, my lord, delay for preparing the MSA appeal. And my lord, 3508 is the abatement. So, my lord,
So
first, my
I
lord,
have to dispose of
the
IA
substitution, yes,
3506 and 3508.
yes, sir.
It is taken note of that by an order dated, these are by this order, this court proposes to dispose of the two applications, which is IAC 3506/2018 and 3508/2018. Full stop. What the 3506/2000, I mean, IA 3506/2018 is an application for 3508/2018 is an application for setting aside the abatement in respect to the, upon the death of the appellant number 1. Setting aside the abatement as regards the appellant number 1, who expired on 1/10/2017. So IA 3506/2018 is an application for substitution of the legal heirs of the applicant number 1, whose names have been provided in paragraph number 3 of the instant application of the application, being IA Civil 3506/2018. Full stop. This court have duly taken note of that by an order dated, what is that order?
My lord, 1/9/2023.
1/9/2023. This court have already condoned the delay in filing the application for setting aside the abatement, which is Miss K IA number 3505/2018. Full stop. This court further takes note of that the right to sue, right to proceed with the instant appeal exists with the applicants with the legal representatives of the appellant number one. And as such, an appellant number one,
The Lordship sole appellant.
huh?
Sole appellant,
appellant.
only one appellant is there, Your Lordship.
Of the, yeah, this for right to pursue the instant appeal exist upon the applicants to the application. So accordingly, this court set aside the abatement insofar as the appellant and further substitutes the legal representatives of the appellant whose names have been duly mentioned in paragraph number 3 of IA civil number so and so 3505 of 2018. And they are arrayed as appellant numbers 1.1, 1 point Roman, 1 point numerical 1, huh? Not Roman 1.
Yes.
1.1, 1.2, 1.3, and 1.4. Who's the counsel appearing on behalf of the applicant shall file a fresh memo of parties before for the appellant, for the applicants shall file a fresh memo of parties before the registry of this court within 7 days from today, and the registry shall on the basis thereof make necessary correction in the cause title of the accompanying application.
Yeah, one Malad 3507 and the main.
In the accompanying application being ISC number 3507 of 2018
And the
and MAC appeal number 876 of 2018. And update the same in the CIS custom. List the registry shall thereupon list the instant appeal for orders for consideration of the application for condonation of the.
No trouble, sir.
Right? You right?
As per office note dated 14/5/25, service report.
Service being completed. LCI having been received, list the matter for hearing in the usual course, liberty given to both the parties to file application for hearings.
18.
Lordship, I have already filed for amended procedural as per order of early order. And service was completed. Matter already LCR has been received. Lordship, matter may be fixed for hearing, Lordship.
Hearing.
Yes, Lordship.
Obliged.
So finally, that may be fixed, Lordship.
2019, I given you the liberty to file application for early hearing.
19 and 20.
Mr.
was
Goswami,
there in
who
the
is
morning?
respond number 2 and 3? Who is respond number 2 and 3?
Owner and driver.
And what is the challenge here?
The appellant had filed this appeal, I have filed a cross objection.
Delay has not been condoned.
Not been condoned. There's one of the two analogous appeals, it's in the stage of hearing. The
Delay for
other-
what?
Delay in filing the cross objection.
This we can allow it. Cross objection to it is between me and you.
Yes.
Yes. Where is Mr. S. Sahu? No, where to be
There in
seen?
the morning, also. First of he was there. He was there also.
Mr. S. Sahu doesn't come in small matters. What is this IA for?
IA has been filed by him.
For
I have filed for enhancement. And he has filed a cross objection with delay petition
for
for
Okay, in fact, also
No, no, that
the
is
cross
okay.
objection is filed underground.
file the cross objection.
yes, yes.
Now we apply order 41 rule 22 applies.
My lord.
Order 41 rule 22 only requires for this code to permit, section 5 does not apply. Does it apply?
Within 30 days. Yes.
Oh, is it
limit
so?
is there.
Let us see order 41 rule 22. I think I must have forgotten what is it.
Within 1 month from the date of service on him or his leader of notice on the day fixed for hearing, 1 month is there.
Or
Or within such further time as the appellate court may see fit to allow.
देखो, I कौन लगो? I civil. There is an application filed for permitting the respondent in the appeal. Respond number?
Question number, Lordship, 1,
2, no, 3.
Respondent in the, respond number 3 in the appeal to file an application, to file a cross objection in terms with order 41 rule 22 of the code. In as much as there has been a delay in filing the said application, filing the said cross objection. So this court have duly taken note of the provisions of order 41 rule 22 of the code and have also taken note of the cross objections which have been taken. This court permits the cross objection to be taken on record, thereby allows the instant application. I extend this cross objection.
My lord,
Cross objection, we admit the cross
one
objection.
sub- yes, because award is less than 10,000. Award is less than 10,000.
no, they are there, total award is more than 10,000.
No,
So,
total.
so, okay, we dismiss your appeal? No, we dismiss your appeal.
Other for enhancement, I have.
No, we dismiss your
Yes,
appeal,
come.
you don't, then his cross objection also goes for a 6. Okay, dismiss.
No,
Then don't raise that. The cross objection. The cross object, this is a cross objection filed under order 41 rule 22 of the code. Challenging the judgment and award dated 28/11/2016 on the ground of, what is the ground?
My ground, Lordship, it is the case of the check dishonour, Lordship, the check had bounced.
On
So
the ground
insurance
that
company-
there was no valid insurance in as much as the check had dishonored. Full stop. Taking into account the above, the cross objection is admitted. Full stop. Mr. S. Sahu appears on behalf of the claimant who accepts notice. Mr. S. Sahu appears on behalf of the appellant. Full stop. Extra copy of the cross objection be furnished to him. Full stop. This is the cross objection for hearing along with MSC appeal number 92 of 2027, 2017. What is the other IA?
Two appeals have been filed.
Eh?
Two appeals have been filed with the claimant, one for damage of the scooty and one for her injury.
This is a, you have asked for stay. IA?
Yes, Lordship. There is one I for application under 41 rule 27, Lordship, for allowing the petitioner to place a copy of the policy on record.
Which one? In which case? How many cross objection filed?
Two cross
Two cross
objections, because
objections,
two appeals were there.
আৰু এখন এলাও কৰিব দেই এনেকুৱা অৰ্ডাৰ দি দিব 1762 এলাও কৰিব হা cross objection admit what is this IA for? Stay.
Stay lordship, one is for stay.
Stay IA has not been registered. Cross objection has also not been registered. তার তলত লিখি দিব cross objection the registry shall register the cross objection and list the cross objection for hearing along with the accompanying appeal. আর এই দুইটাতে এনেকে অর্ডার দিব দুটা cross objection আৰু IA for stay এখনত দিছো এই দুখন লিখিব stay what you don't want 10,000 you want that.
No, I want, because I have come for enhancement.
You want more money?
But by the time if they pay 10,000, well and good.
You are not insisting. Now, as you ask for a higher amount. Are you asking for this 10,000?
Actually, they have to deposit certain amounts, I think.
25,000 they have already deposited. No.
No, lordship, no.
Oh, you have to do that.
But I'm a little unfamiliar with this because this
Ah.
appeal was earlier filed
Yeah,
by
cross-objection
Mr.
cannot be
Amran Doctor
admitted.
Lordship. Yesterday I could sort out the papers.
No, cross objection cannot be admitted without you
Lordship,
depositing.
I'm again, because what has happened, Lordship, in this case, I did not file this cross objection. It was earlier dealt by Mr. Amran Doctor. I got it and
But without deposit of 25,000.
I'll go through the papers. Lordship.
Go orders of cut-off.
I'll go through the papers, Lordship.
In both the
fact,
protect the appeal দিব হ্যাঁ
I could only-
আইনত দিব এই 1762 লিখিব এটা আৰু ইখনত লিখিব যখন এই আছে ঠিক আছে 1808 পুস্তক বেলেগ ধৰণে The instant application has been filed under Order 41/22 taking leave of the court to file the cross objection against the judgment and decree dated a date to silence. It is relevant to take note of that the cross objection has been filed by the appellant insurance company, by the insurance company who is the respondent number 3. First, the question arises as to whether the cross objection can at all be permitted without the deposit of 25,000, which is the mandate of law. First, Mr. Argusami submits that he will obtain instructions and place before this court. List the matter again on 9th of June. Not admitted.
I'm sorry, Lordship, I took time to.
25,000 has to be there.
21.
Service complete.
So far as respondent number 1 is concerned, not come.
Who is one?
One is the insurer of the offending vehicle. But there is a dispute because the learned tribunal tells that,
You are,
I am the claimant.
you want more money.
No. We say that the insurer to whom it has been directed to pay is the insurer of the vehicle where my son was traveling. It should be the insurer of the truck. Now, why we put up the submission? Because in that vehicle, when the accident had occurred, 4 persons died. So different cases were filed and different appeals were filed. In some cases,
The service is not
no
complete.
one, respond number 1. We may take steps now.
The service being not complete, upon the respondent number 1, list the appeal after completion of service upon respondent number 1.
We need to take fresh steps. We need to take fresh steps.
When you want to do it, that is your lookout, you don't do, matter will be pending.
22.
Service,
We have taken the dusty service and filed the affidavit. For them, I'll understand. He will appear.
service complete. What is the matter about?
Chief.
there is a concurrent pending from the trial court to second appellate court. And we have filed execution. Then execution case was dismissed on the point of limitation, ignoring the Article 136 of the limitation clause.
Oh, that matter came before me.
Yes.
One day
earlier.
I was about to allow.
Yes, earlier.
Ah, because you say that it has been modified by, yeah, by one
First
month,
appellate court.
by
Trial
1
court-
month,
Trial court given 1 month.
1
Then
month,
appellate court given 3 months.
3 months.
And-
And so from that 3 months, it is not 12 years.
Yes,
Because the 137 category, 136 categorically says
yes,
the second part.
yes. The decree or order become enforceable or where the decree or any subsequent order directs any payment of money or the delivery of any property to be made at a certain date or a recurring period when default in making the payment or delivery in respect of which execution itself takes place. So starting point will be after that expiry of the 3 months. If that is so, Lordship, it is within time. And this provision has not been taken into account while passing the interim order. And I also placed one judgment, Lordship, in this respect.
Which one?
2004 8 SCC,
Whose judgment?
3 judge judgment, Lordship.
Name, author?
Lordship, Honorable Justice SB Sinha.
This was a case where he had taken into account the other Raghunath judgment also, na?
Yeah, that. Lordship, these all provisions of the
Yes,
limitation.
Ratan Singh judgment.
Yeah, Ratan Singh judgment. That is
Ratan Singh
distinguished on
judgment
fact.
and therefore, here it says that the doctrine of merger
Merger.
applies and as such it will be from the day.
Yes. That cannot exist.
Chalo, let us allow this.
No, my lord, I have, my lord, the first part will apply.
How?
Because going by Chandi Prasad, my lord, it said there can be only one judgment, which is executable. Now this first appeal, where this grace period of 3 months was given, that grace period already expired, it came in second appeal. My lord. Second appeal did not give a time frame.
No, second appeal dismissed it.
Second appeal dismissed.
So therefore, that first appellate decree becomes confirmed.
Correct, my lord. But Chandi is saying that even SLP, whatever, be it reversal, affirmation, whatever.
No. Here it says, Sandhi says, if it is a mere dismissal without anything, but if it is dismissed on merits, then the question is different.
Yes, yes. So
But this is
therefore,
dismissed on merits.
yes, it is dismissed on merits, and therefore the appellate decree, my lord, doesn't give that grace period of 3 months, 1 month, whatever, my lord. So it will start from the date of that judgment.
No. The appellate decree has been dismissed. Allowed. The appeal has been filed, 3600, section 100. Here you kindly see the change in law. Here it says, no.
Merger is.
Merger.
Once a decree is sought to be enforced for the purpose of execution thereof, irrespective of being original of the date of the decree or any subsequent order directing any payment, the extraordinary announced by the High Court in upon entertaining the appeal in a full hearing in presence the same who replace resolution of the law court.
Para 26 of your lordship.
Para 24.
When an appeal is prescribed under the statute and the appellate forum is invoked, and the same for all intents and purposes to continue. The document right between the appellate court process and between the decree of the High Court merges with the decree of the appellate court. And even if the subject of the modification that may have been made in the appellate decree, the decree of the first the decree of the trial court. And afterwards, the merger of a decree takes place irrespective of the fact that whether the appellate court affirms So what is the formal decree drawn out here in the High Court?
No decree was, my lord, the judgment, the decree they have not annexed, my lord. We are not, I tried to check up with the record. Perhaps decree whether drawn up or not drawn up, not.
Appeal will be dismissed.
Now, my lord,
The judgment also, the judgment will speak of the decree, the
Yes.
appeal is dismissed.
yes. So therefore, my lord, going by, the Munsif court said, the court of Munsif said 1 month. So it became executable after 1 month, but by virtue of second part of 136, my lord. Appellate court said 3 months. So therefore it becomes executable after 3 months as per the second part. High court doesn't say anything. High court doesn't fix a time.
The High Court has dismissed it,
Dismissed it.
meaning they are affirming the judgment, so
but-
it will be, so this period cannot be taken into consideration.
Yes, this period cannot be taken into consideration because of 15, section 15. Now, if this period is not taken into consideration, then the RSA dismissal is 14/8/2001. Till 12 years will remain. So 12 years would end on 14/8/2013.
14, what are the judgments of the trial court?
Judgment of the trial court was 31/7/1989.
7/1989.
1 month's time allowed.
Okay. Then
12/8/1984, that's a dismissal of the title appeal.
1984, title appeal,
3 months time period given.
3 months. Okay, then
And then 14/8/2001, dismissal of the
Appeal.
RSA with no grace period given. Now, if my lord has 136 for a moment, 136 has 2 parts.
The other judgment, Lordship, paragraph 13 and 16.
Ratan Singh,
This one, yes, Lordship.
Pella,
Paragraph 13, Lordship, near Pleasitam Sikh relying on one judgment. That position was adopted in the background where the appellate court affirmed the decree of the lower court, though with a slight modification regarding the cost portion. Here, our period.
such a situation,
In
it
such a
was
situation,
rightly
it
held
was
that the
rightly
appellate
held that
court's
appellate court
decree
decree become
became enforceable
enforceable
and
and
hence
the
the
time
time
would
would
start
start
running
running
from
from
the
the
date.
date of the.
Correct, correct.
And 16, Lordship, as no decree was passed by the High Court in the second appeal, the decree of the first appellate court remained unaffected and the enforceability once commenced remained undisturbed from the period of 12 years thereafter.
Where, which paragraph?
The
you
paragraph
read?
16, Lordship.
The decree became enforceable on 1/8/1973 when the appellate court passed the decree which superseded the decree of the trial court. And as no decree was passed by the High Court in the second appeal, the decree of the first appellate court remained unaffected, and the enforceability once commenced remained undisturbed for a period of 12 years therefrom. The execution proceedings initiated by the appellant long after the period expiry of 12 years from 180 is thus irretrievably bad.
On the
But
text.
here is the case, in Ratan Singh, the appeal was dismissed. The appeal was dismissed on the grounds of delay.
Yes.
So therefore, there is no decree.
There is no.
And this clarification is being given in by,
Chand.
in the second judgment.
But this 13, Lordship, paragraph 13, it's relying on one.
Learned I have
other
cited the
judgment.
judgment of the two judges as the bench repelled the contention that the time would start running from the date of the decree of the learned trial court when the appellate court did not. That position was adopted in the background where the appellate court affirmed the decree of the learned trial court of the lower court, though with slight modification regarding the cost. In such a situation, it was rightly held that the appellate court's decree became enforceable, and hence the time would start running from the date of the decree. So me imposing a cost of 11,000 is in fact a boon. Isn't it?
It has section 15 for a moment.
Now, paragraph 23 and 24 is relevant. The doctrine of merger is based on the principle of 24. It is right that when the appellate court passes a decree, the decree of the trial court merges with the decree of the appellate court. And even if the subject of any modification that may be made in the appellate court's decree, the decree of the supersedes the decree of the trial court. In other words, merger of a decree takes place irrespective of the fact as to whether the appellate court confirms, modifies, or reverses the decree passed by the trial court. When a special leave petition is dismissed summarily. Now, here is a case where 3 months was granted and the appeal was dismissed,
Second appeal.
thereby affirming the judgment. Which therefore means that the appellate court judgment of giving you another 3 months continues.
Yes.
That has not been interfered with.
No, my lord, we'll have section 15 for a moment. My lord, I
The
view
delivery of the property lots.
Understood? The appellate court permitted 3 months. Thereupon an appeal was filed.
Continuous.
Appellate court does not interfere with the judgment, but in fact confirms it.
Yes.
When it is a judgment of confirmation, that period of 3 months will start from there.
Yes, that is the period by which they have to deliver the position. If they deliver the position of within 3 months, then execution case would not right. Since they are default.
Let us take another example. The appellate court says that a person will be giving some possession to somebody. After or specific performance will be done in a particular manner. The second appellate court confirms it. I need to understand that what has been mentioned by the when it is a case of affirmation on merits, are we to understand if it is an affirmation on merits, what is being directed by the first appellate court would not hold the field. Because it's an affirmation. If it is modified, obviously that modification will take effect.
From if had the second appellate court modified the order, then it would have been because
Including
because
cost.
of the merger. And that section 15, my learned friend is even discussed in this case also. There are 16 onwards.
Have they?
16, 18, 20, 21.
I delivered one judgment of some Mr. Hawk.
My lord, two things. My lord. I'll just formulate the submission. Appellate court says you vacate within 3 months on 12/8/1984. my lord. That 3 months has spent its force, my lord. Now, your lordship will imagine a situation if I would have, after the affirmation of the decree, my lord, if I would have prayed for a grace of 3 months on that particular day, post the dismissal of the RSA, then perhaps the courts would have said that that 3 months had already spent its force, my lord. Similarly, if it were a decree for specific performance and there would have been a prayer for rescission.
Okay, when did you file your petition?
25/9/2013.
25/9/2013.
Because they've availed the longest period of limitation, my lord. That's
They would like to do so. And it was dismissed by which order?
26/4/23.
4/2020. So if it is 12 years, otherwise it would have end on 24, 13,
Lordship,
13,
second appeal
8,
dis-
2013.
Second
Second appeal dismissed on 14/8/2000.
So as per you, it would otherwise end on 13/8/2013. And it was filed on 25/9/2013.
Then 3 months, Lordship, it will come to
Okay, don't worry.
12/11/13.
My lord, last submission for section 15. My lord, another issue. My lord, they themselves filed an application under section 17 on the notion, that's not even a ground here, on the notion that we have exceeded the limitation going by the last date of the judgment in RSA. And they sought exclusion of time on the ground of fraud, my lord. That is when this order was passed. So it was never their case that it is within limitation. They admitted to the proposition that it is beyond limitation, and therefore we need to get it excluded under section 17. Now, my lord,
Mr. BD Deka, from the morning onwards, I've been all correcting this type of error. Don't worry. We heard Mr. J. Deka, the learned counsel, appearing on behalf of the petitioner, and Mr. BD Deka, the learned counsel, appearing on behalf of the respondents. The supervisory jurisdiction of the court have been invoked to challenge the order dated 2023.
Yes.
23, passed by the learned Munsif number 1, by the learned court of the Civil Judge Junior Division number 1, Gwalpara, in title execution case number 10/2023, whereby the learned executing court, whereby agote by the Civil Judge Junior Division number 1, Gwalpara logot bracket eta di dibo learned executing court, whereby the learned executing court dismissed the execution application filed by the petitioner by allowing the petition filed under section 47 of the Code of Civil Procedure 1908. Full stop. The facts in the instant case are that the petitioner the predecessor in interest of the petitioners had filed a suit before the court of the learned Munsif number 1, Gwalpara, which was registered and numbered as title suit number 70/1985 against one Abdul Wahab, the predecessor in interest of the principal respondents herein. The said suit was decreed by the judgment and decree dated 31/7/1989, whereby the learned court of the Munsif number 1, Gwalpara, granted the reliefs sought for in the suit, and the defendant in the suit was directed to vacate the disputed land within 1 month from the date of the judgment and decree. And failing which the defendant would be evicted from the disputed land in the process of law. The defendant thereupon preferred an appeal before the court of the district judge Gwalpara, which was registered and numbered as title appeal number 18/1989. The learned district judge Gwalpara, by its judgment and decree dated 12th of August 1994, dismissed the appeal. Dismissed the appeal and affirmed the judgment and decree passed by the learned Munsif number 1, Gwalpara, dated 31/7/1989. However, in doing so, the learned district judge Gwalpara, who was the first appellate court, granted the defendant 3 months' time to vacate the suit land. The defendant thereupon preferred an appeal before this court which was registered and numbered as second appeal number 178/1995. The coordinate bench of this court by the judgment and order dated 14/8/2001 dismissed the said second appeal. In doing so, the coordinate bench of this court had observed that no case for interference arises in the appeal. With the judgment and decree passed by the learned first appellate court. First, it is further relevant to take note of that on 25/9/2013, the execution proceedings was filed by the decree holders, which was registered and numbered as title execution case number 10/2013. The petitioner, the respondents herein, the principal respondents herein, who were the judgment debtors, filed an application under section 47, stating inter alia that the said execution application have been filed after a lapse of 12 years, 1 month, 11 days from 14/8/2001. And as such, the same was barred by limitation in terms with Article 136 of the schedule to the Limitation Act 1963. It is further relevant to take note of that pursuant thereto, a petition was filed by the decree holders under section 17(2) of the Limitation Act, praying for extension of the period of execution. The learned trial court, the learned executing court, by the order dated 26/4/2023, dismissed the said application, allowed the said application filed under section 47 and dismissed the execution proceedings. And it is under such circumstances the present proceedings have been filed. Mr. J. Decker, the learned counsel, appearing on behalf of the petitioners. Petitioner or petitioners?
Petition.
One.
No.
Petitioners. Appearing on behalf of the petitioners, submitted that by the first appellate court's judgment and decree dated 12/8/1984, the decree was made effective after 3 months. The decree could have been put to execution only after 3 months from the date of the judgment and decree. He submitted that the appeal filed thereagainst was dismissed on merits and without modifying the judgment and decree passed by the learned first appellate court. Or in other words, the learned first this learned second, this court, the coordinate bench of this court had this court had confirmed the judgment, affirmed the judgment and decree passed by the learned first appellate court. Full stop. He therefore referred to the judgment of the Supreme Court in the case of Ratan Singh versus Vijay Singh and others reported in 2001, 1 SCC 469, as well as the judgment of the Supreme Court in the case of Chandi Prasad and others versus Jagdish Prasad and others reported in 2004, 8 SCC 724. Per contra, Mr. B.D. Decker, the learned counsel appearing on behalf of the respondents, principal respondents submitted that the appellate decree, that the decree passed by the learned first appellate court, dated 12/8 to 1984, though had granted 3 months of time. But the appeal there against, but the on 3 months of time. But in view of the doctrine of merger, the said first appellate decree no longer survives and it merges to the judgment and decree passed by the second appellate court, by this court. And as such, the period of limitation has to be taken with effect from 14/8/2001. He further submitted that in the instant case, the petitioners also knew that there was a delay, and as such, they had filed a petition under Section 17(2) of the Limitation Act 1963, explaining the delay. And under such circumstances, the learned court below had not committed any error in jurisdiction in dismissing the said execution proceedings and allowing the application under Section 47 of the code.
And that the first part of 136 would apply.
That is what you say, na? It will apply 14(8). Mr. B.D. Decker further laid emphasis that in the instant case, the first part of the Article 136 of the schedule to the Limitation Act 1963 would apply, and not the second part, taking into account that this court had the judgment and decree passed by this court had taking into account that the learned first appellate court's judgment and decree had merged with the judgment and decree passed by this court. Satisfied? I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. First, this court have duly in the previous segments of the instant judgment have duly mentioned the dates on which the judgment and decree was passed by the learned trial court, the learned first appellate court, as well as by this court. First, the learned trial court, though, had decreed the suit in favor of the plaintiff by the judgment and decree dated 31/7/1989. And thereby granted 1 month time to the defendants to vacate the suit property. The first appellate court, but the first appellate court, while affirming the said judgment and decree, passed by the learned trial court dated 31/7/1989, only modified the said decree to the extent of granting 3 months' time to the appellants, to the defendant, to vacate the suit property. It is seen that thereupon the appeal had been preferred by the defendant and the appeal was dismissed without there being any modification to the judgment and decree passed by the learned trial court, by first appellate court. First, it is also seen that the judgment and decree passed by this court is merely an order by which merely passed by this court, though merges, it is further relevant to take note of that the judgment and decree passed by the first appellate court, though merges with the judgment and decree passed by this court, but as there was no modification to the judgment and decree passed by the first appellate court, rather it was a confirmation of the judgment and decree passed by the first appellate court. It has to be understood that this court have also permitted 3 months time to the appellants, to the defendants to vacate the supremacies. First, taking into account the above, it is the opinion of this court that the second part of Article 136 of the Act of the schedule to the Limitation Act 1963 would be applicable, and the period and the appellant and the petitioners herein could have filed the application on or before 13/11/2013. First, and the execution application was filed on 25/9/2013. In the opinion of this court, the same was within the period of limitation. Accordingly, this court sets aside the impugned order dated so-and-so and restores the execution proceeding being execution case number so-and-so to the file of the court of the court of so-and-so, civil judge so-and-so. And the learned so-and-so shall proceed with the execution of the said proceedings in accordance with law. So taking into account that the proceedings being titled execution of case number so-and-so has been restored to the file of the learned executing court, this and the parties are duly represented, they are directed to appear before the learned trial executing court on 18th of June 2025 for further proceedings of the execution.
Regarding yesterday's.
Oh, yes. Tell me. What do you think? I tell you the story. You must, are you aware of the facts?
Not really.
There is a, otherwise, I've also seen the recent judgment of Justice Pardiwala on what he says about Order 20, Rule 18 and all. Now, let me tell you the facts. Here is the case. A property belonged to two brothers, of which the plaintiff number 1 to 4 and the defendant number 2 were of one branch, and the defendant number 2, 1, and the performer defendants were of the other branch. Now what has happened? The plaintiff, the defendant number 1, who was of the other branch, he executed a deed of sale along with the defendant number 2, and the total property was 4 kathas in the year 1985 in favor of the defendant number 4. Although the defendant number 2 share would have been at best 8 lectures because there are 5. So, but he sold 2 kathas in favor of the defendant number 4. The defendant number 4 in turn sells 1 katha 16 lecture to the defendant number 3 and 2 katha 4 lectures to the performer defendant number 2.
The whole is accepted.
Whole is done. Now the plaintiff thereupon files a suit seeking recovery of possession as regards 1 lectures, as well as for declaration that the sale deed, that a gift, there is some gift deed is bad and all these things, and for whatever maybe, for it also says that to recovery of possession as well as for, this is very important, for recovery of possession, and also that if recovery is not possible without partition, then for partition. The trial court, what it does is the trial court passes an order to that effect, judgment and decree in favor of the plaintiff, and thereby says that the entire sale deed is bad. Appellate thereupon also says that subsequent deeds are also bad, and further directing handing over of the possession of this 12 lectures. Appeal filed. At the time of that, the plaintiff number 1, who was the mother of the plaintiff number 2, 3, and 4, and the defendant number 2 expired. So now the shares change. Now, the appeal also was dismissed by confirming the judgment of the trial. Appeal filed before this court. I hold that the suit was maintainable. They had a right over this 10 lectures. I also hold that as the others are in possession, the question of therefore without a partition being done, it is not possible. And there is a case of recovery of possession. So recovery of possession can happen only after this partition. So I give the partition. Now, interestingly, the defendant number 2's share was 8 lectures, but during the appeal, it became 10 lectures. Although the suit, at that time, the decree was passed up to 8 lectures. At that point, when the sale deed was made, it was 4 lectures, but he had only power at that point of time only for 8 lectures. But in the meantime, in the appeal, it changed. Now, I say that the plaintiff's hearing would be entitled to 1 katha 10 lectures. 2 kathas will go to the defendant number 2 because it will 8 into 2. Now, the question is, 1 katha 10 lectures, he gets it, there is no quarrel. Now, the sale deed which has been made in favor of the defendant number 3 is prior to the sale deed which has been made in favor of the performer defendant number 2. Now, the performer defendant number 2 sale deed, so the in view of 48,
This will prevail.
priority will take place. So, as regards the defendant number 3, 1 katha 16 lecture you cannot touch. So now, 2 katha 4 lecture which was being sold has to be taken out from that portion of the performer defendant number 2, taking into account her rights could be only limited to 4 and 8, 12 lectures. Uh, 12 lectures. So that will be only 12 lectures. Now the question is, 1 katha 10 lecture, 2 lecture, 1 katha 16 lecture, and 12 lectures. 2, 4. Now I have already given that these are the particular area. Area is being now specified. Now it has to be done by meets and bounds. Now here is the case, should I go for a final decree or a composite decree of being preliminary and final, or a preliminary decree? Now, if you see the judgment of the Supreme Court in this, Justice Patiwala, it says one can very well go for a very well pass a decree under Order 20 Rule 18A, 18.1, and then he will do by meets and bounds and thereupon hand over the possession. Now that is one. But in certain places they use the word agricultural land. Now here is another case where there is a question that there is a constructed house by defendant number 3. And now defendant number 3, constructed house. It is not therefore a pure land. It's just vacant land. It is not so. So there will be some constructed land. Now, if I pass a preliminary decree or a final decree, now how do I give the declaration of their right title in interest in respect to that pata number or dark number, which would happen later on? I may say very well that they are entitled to one katha, but the moment I say that, because a further thing is required to be done by the collector, he has to be done. Now, how do I give the direction as regards recovery of possession? Can I give it or not? And if I have to give it, then in that case, it has to be a preliminary. This is the basis on which I have asked.
There's a full bench judgment of our High Court, which said that the collector will do everything. Now, but then there is also this judgment of Shubkaran Bubna. I've not got it. It says that if there is a standing structure, it has to be through 18(2).
No, no. If the standing structure belongs to another person or jointly, it has to. But here there is no quarrel with the fact that this standing structure was made by the defendant number 3. There is no quarrel with that fact. Understood, if there is a standing structure out there which can be done amongst both the plaintiff and the defendants may have a right over it, yes, there's no quarrel with that. It has to be a composite decree. But here in this case, the standing structure belongs primarily to the defendant number 3. There's no quarrel.
So the moment that is there, the adjustments have to be done, so a need for further inquiry perhaps would be necessary.
Well, the area cannot be different.
Area cannot be different.
Area has been asserted. So if the area is ascertained, then does it require the DC to go for further in view of section 100?
No, then perhaps this judgment that I'm talking about, Shubkumar Karan Bhutna, it says that then it has to be not to be done by the revenue officials alone. It has to be by architect, draftsman, or advocate commissioner.
No. For this, it is not required. How do you bring in the architect or draftsman the anything out here? Here I am ascertaining. He is entitled to 1 kata 10 lectures of this patra.
Right, but they can look into corresponding valuation of whatever is falling in. Will they not? If it is a decree under 18(2), no doubt the shares have to be declared in the preliminary decree, but the corresponding adjustments can be made during the final decree proceedings.
But that is not being asked for. If somebody asks for the rendition of accounts, then the question would have come in. But here, does it come in here? For that, obviously, that has to be preliminary. There's no quarrel with that. But here, this is a purely real land. But only there are structures now being created during the pendency of the suit.
During the. Then perhaps.
No.
This judgment perhaps may throw some light.
Give it to me. Let me think about it. Only thing is, my only worry is, Mr. Dega, only worry is, because of me passing a final decree, later on the plaintiff should not be affected. But one thing, another very important thing, the performer defendant number 2 is not before the court. This is the major problem.
But he will be anyways put to notice, because if that
He will put
principle.
to notice, but he is not before this court. And in fact, they didn't file the appeal again. In the appeal, they did not appeal because they are the joint responsible.
question here was at para 3, the reference.
4 judges. What is this 4 judges level 3? 4
But
judges.
this I tried to get it in SCC online. It is showing the order of the reference. But here it seems to be authored by Justice Goel.
Therefore, I think
UB Saha, Justice UB Saha was perhaps not there if I've seen it. It was just Justice Goel, Roy and para 3 was the consideration, right? Which your lordship had queried that who takes care of the rest once it's under 18(1).
if you have the judgment of Justice
Particular.
only come to this paragraph of there. And more particularly, I like the judgment of the Karnataka High Court, where they have made a reference to. It's a very nicely done judgment of Karnataka High Court. Finally come to here, paragraph 51.
51.
Paragraph 51. It is now a well-settled principle of law that in the case of an execution of a decree pertaining to partition and separation possession of the agricultural land assessed to revenue, the civil court only declares the shares of the parties, and the authority concerned has to effect partition or division by metes and bounds, as envisaged under section 40 of the collector is the authority concerned to effect partition. Once the papers were sent, the civil court has no control over the proceedings taken by it. The civil court cannot direct the collector to effect partition in a particular manner after the papers were sent. Therefore, section 54 makes it clear that the execution is not at all contemplated in a case of a decree for partition and division of agricultural land. What the civil court has to do to transmit the papers of the collector for Iman. Now, here, only here, therefore, the appellant rightly held the execution petition filed in the case are only request. Then here says under 54 Iman is to effect the partition in accordance with the law relating to partition of the. The word partition, in my opinion, means partition is not confined to mere division of the lands concerned by requirement, but also include the delivery of shares to the respondentalities. So the power is being given to the collector. To elaborate further, the word partition means actual division by metes and bounds and handing over the possession of the shares to the parties.
So does the full court also say this?
As an instance of the law relating to partition of so and so, so and so. Therefore, section 54 in mind does not enable the heir to decide the question as to whether agricultural land in question is impartable or immutable. This is the duty of the heir and not for the deputy commissioner. So therefore, once I hold it that you go under order 20 rule 18(1), although with due respect to the Supreme Court, I have a difficulty in accepting this paragraph of the judgment.
47. It says it will never come back to the court again.
46.
46. That I've seen. That this also would be taken to be a preliminary decree only, even under 18(1). I think that's what they say. The character of the decree under sub-rule 1 and sub-rule 2 of order 20 rule 18 is the same. It is true that the decree passed under sub-rule 1 of rule 18 is not described as a preliminary, and the decree under sub-rule 2 is declared as preliminary. There is no real difference between the two, in as much as under both the provision, the court determines declares the rights of the parties, and under both sub-rules, partition, separation, or division by metes and bounds has to be effected thereafter. Whereas under sub-rule 1, court affects partition. Under sub-rule 2, it is the collector effects partition. Under sub-rule 2, it is the commissioner appointed by the court who undertakes the said exercise.
But this does not go with this paragraph, no? It's Karnataka paragraph 7 and also paragraph 48 of the say judgment, where they refer to another Supreme Court judgment when it says that if it is a preliminary decree, you cannot do execution unless there is a final decree. Now, therefore, the question of delivery of possession they will do. How do I put the injunction?
Delivery of possession, they will do it. That our High Court is also saying. In fact, execution, High Court has gone as far as saying that execution also, they'll only do it.
No, they will do. Because they have to do it.
Can
You can't involve us.
Because they're more conversant with the land, etc. That was the reasoning that was cited.
Chalo, ठीक है. Thank you.
Obliged.
Yes. Other matters? Any urgency? I have to take up item number 1, 2. किसी में तो नहीं. तो हो ही गई. मुझे date नहीं लगी अभी तक. Okay, let me complete these matters. Yes, item number 23.
23.
May allow us to take steps upon respondent number 2, let's say.
Okay.
On
Steps
respondent number
be
1.
taken upon the respondent number 2, first by way of registered and usual, and the matter be listed after completion of service upon the respondent number 2.
24.
Service is complete. The matter for a hearing in the usual course, liberty given to both the parties to file application for early hearing.
25 to 27.
Service is not complete, Mr.
Not
Jain.
complete. I may be allowed to take fresh steps with the correct address I will.
Mr. R.K. Jain submits that he may be permitted to take fresh steps upon the respondents in the correct address. Pusto,
By registered
or
post.
by way of registered post. Accordingly, let the steps be completed, be taken on or before 16th of June 2025. Pusto, thereupon the matter be listed after completion of service upon the respondents.
28.
In all the three cases. In all the three cases.
28.
What is this? I for
This for stay lordship. Stay lordship.
stay.
Have the impending order.
It's an order of maintenance, my lord.
What is this order? Case about?
So this involves, my lord, a divorce suit was filed, my lord, by the husband, my lord, who is the petitioner herein. And in that, my lord, proceeding, I have filed as the wife, I have filed a petition under section 24 of the Hindu Marriage Act for maintenance. I have been granted the maintenance for myself and the child for 15,000 a month. He is paying 5,000 a month, and that too after every 2-3 months when the court acts strictly. And he has challenged the quantum of the.
What do you do?
Lordship,
What do you do?
he's a petty businessman, lordship.
Petty businessman?
Yes, lordship.
What is the petty
He's a-
businessman?
He's a, this, shop lordship, lots of lordship.
Where?
Where? Huh?
Ojai town. Ojai town.
Inside the town?
No, lordship, it is a very small GMC shop lordship. It
GMC is only here in
inside,
Guwahati.
inside market lordship there, sorry. Municipal boards stall lordship, mini stall. The mini stall, the rent is only 350 lordship. That is the quality of the shop lordship. The rent is 350 per month lordship. This is the mini stall lordship. So his as per his income tax return lordship, his annual income is 3,90,000 lordship. It is 32,000 something lordship per month. He is having his old ailing parents lordship. 15,000 is too high lordship. What my submission at this stage is lordship, during pendency of the hearing, your lordship may give us direction to pay 50% of the amount. I have been paying 15,000 lordship as of now. After the order lordship, we have been paying 15,000 per month with great hardship. By out of 32,000 per month earning lordship, I have to maintain myself as well as my old ailing parents.
You take all the money in by PTM.
Lordship.
No, all shops selling is by PTM.
Lordship,
There is no cash transaction.
no lordship.
But
I
his
have been
income
paying lordship income tax. Lordship,
Income tax.
lordship, this as per the
What is the value
direction of
what-
Rajneesh and
Mr.
Nehal lordship.
Counsel, file an affidavit, what is the value of your stocks in the shop? We
Lordship.
don't know, we know
Lordship,
about that.
Lordship, as per the direction, as per the mandatory direction of Honorable Supreme Court Lordship in Rajneesh and Neha, Lordship, I have been paying the affidavit in respect of my assets and liability, including by 3 years, all these income tax return, Lordship. That has not been considered by the learned trial court, and that is mandatory by the Supreme Court, Lordship. Neha and Rajneesh, Lordship, guidance for all the magistrate as well as the family court, Lordship. I may submit the copy of the judgment to your Lordship.
Item number 28, list the matter again on
It's for admission, it has come for orders for some reason. It should be for admission.
is the matter for admission on 6th of June 2025, on which date an attempt shall be made to dispose of the entire proceedings.
29,
Yes, Mr. Mahmood.
Number 2 and 3 have been served. One is not served, but as per Lazima court's order, that is 3425, it may be presumed as served.
LCR? LCR? It is not seen from the LCR আইছে না চালু যদি LCR আইছে then the registry shall inquire, shall place, shall list the matter again on 9th of June 2025, stating by providing a report as to whether the LCR has been received.
Service of respondent number 1 may be presumed as served.
It's okay, we'll do it on that date. We'll do it on that date.
30, item 30,
List the matter for admission on 11th of June 2025.
1,
Service report.
What is that matter? Let us finish small matters we should.
Voting
CRPIO,
part.
service not complete. What have you done?
No, today, my lord, matter hasn't come for disposal.
Don't worry. I dispose it all on those matters.
My lord, I need to have the preparation, my lord.
Mr. Professor, you are such an,
I did not even look into the petition, my lord. I thought, my lord, away service report. Any date on next week, my lord. If a lordship wants to dispose
list
of
this matter for admission on 26th of May 2025.
out of station.
26th of May 2025, interim order passed earlier shall continue.
No, 20 out of station.
Okay, 28th of
Then
May.
lordship fix the matter on first of the second of.
28th of May. Interim order passed earlier shall continue.
And what about the, my lord, notice?
Not necessary. This is a case for dismissal. Today I permitted you only.
32,
What is this?
Lordship, this present appeal has been filed under section 23 of the Railway Claims Tribunal Act against the judgment passed by the Railway Claims Tribunal. Lordship,
Rera? What is this second appeal filed?
this is an appeal, miscellaneous first appeal filed under section 23 of the Railway Claims.
Item 32.
32,
Apology, man.
What is this 32? What objections are filed?
My lord, they file objections.
For what?
My lord, for injunction, my lord. I is for injunction, my lord. My lord, this. My lord, the petitioner appellant has filed a suit bearing number TS 25. of
What,
the
you want an injunction?
Yes,
They file objection.
yes,
Trial court, did you, in an RSA,
yes,
RSA has been admitted.
yes, ma'am.
Admitted.
Yes, ma'am.
What injunction you are asking for?
My lord, over the scheduled land, my lord.
What injunction you are asking
My
for?
lord, temporary injunction.
For
my lord,
what? Temporary injunction means tomorrow somebody getting a money on some status quo. What injunction are you
My
asking?
lord, status quo, my lord.
Status quo
Yes.
as regards possession, title, interest, which one?
My
What do you
lord,
want injunction for?
My lord, parties may maintain status quo over the schedule. my
For
lord.
what? As regards not to sell,
Yes, my lord, and
as
not,
regards possession. Who is in possession?
my lord, they are in possession.
Okay, now what do you want? They,
My
they
lord-
should not construct.
Yes,
Now, how many courts you have lost?
my lord, one, my lord, in the first appellate court.
And the trial court?
My lord, that was decided in our favor.
Plaintiff,
Yes,
you are constructing?
No, Lordship, the allegation as shown in the injunction petition, that cause of action shown in the second week of December 2016. And a petition was filed.
No, no, I am asking you, are you constructing?
No, Lordship, have been denied.
Don't construct. No, I could do. I have 13. You are not constructing?
No, Lordship.
So we pass an order of status. Heard Mr.
GMTS.
Imtiaz, the learned counsel appearing on behalf of the applicant, and Mr. R. Sharma appears on behalf of the respondent.
Respondent 21, 22, 23, 24, 31 and 32, Lordship. I'm not for receiving number 1. 21 series and 3 series. Lordship.
You are appearing for? Who appears for 3?
The 3, Lordship. 21 series, 2 series and 3.
Okay, you appears for 21, 22, 23, 24,
And
31 and
31
32. Mr. So-and-so appears for respondent number 4 and 5. And who appears for 1?
My lord, no one has
He
appeared.
did not contest before a trial court as well as before a first
Okay.
appellate court.
None appears for respondent number 1. There is an application filed seeking a temporary injunction restraining the opposite parties herein. Opposite party will go, respond no karo. Herein, their agents assigned attorneys, promoters and developers for making any further construction of the suit property as described in the schedule appended to the plaint, appended to the said application. Full stop. It is seen, hey, I'll check on this. It is seen that by an order dated 1/10/2024, the accompanying appeal has been already admitted by formulating 3 substantial questions of law. First, taking into account that the instant appeal is, this court inquired with Mr. R. Sharma appearing on behalf of the respondent numbers 1, 2, to the appearing on behalf of the respondent numbers 21, 224 and 31 and 32 as to whether there is any construction being carried out by the said applicants. Gustav, it has been mentioned that the said respondents are not carrying out any construction. Who is constructing?
My lord, they are constructing, my lord.
They are not constructing. Your allegation is against them.
It's as well as the respondent 1, my lord. He is not a-
Gustav. The learned counsel, the applicant submits that the respondent number 1 is also taking steps for construction. So taking into account that the appeal has already been admitted by formulating a substantial question of law, this court is of the opinion that the status as regards the property be maintained. Status as regards the property insofar as construction be maintained till the disposal of the instant of the accompanying petition. Accordingly, the I stands disposed. Full stop. This court, however, grants liberty to the opposite party to approach this court by filing appropriate application. If if the appeal stands pending for a long period, to approach for modification.
Much. If you the justice service, we have filed an affidavit, it is not on record.
You filed at the service?
Yes.
When?
On 6/5/25.
Aitani?
Because I have gone through the record, it is not there.
Not come. Okay, justice service आना ही नहीं.
Affidavit is not.
Okay, Mr. M. Dotto. U. Dotto submits that the steps by way of justice service have been taken. So however, the said affidavit is not on record. Who's to list the appeal again on the registry shall inquire into the said aspect and thereupon list the matter again on 4th of June.
34,
Service complete?
If Lordship permits, Lordship, I am appealing for respondent number 9 to 12, Lordship. I got an instruction.
And others?
Other hearing for 1 to 5 minutes.
Who appears in between those persons?
My lord, kindly see, my lord, respondent number 6 to my lord 8 are the sons and daughters of respondent number 4, my lord. Sons and daughters, my lord.
Don't be clever.
I have to take instruction on that.
Appear.
And as per this honorable court order dated 17/25 and office note dated 5/5/2025, they did not take justice service yet. As per office note dated 5/5/2025, they did not take justice service yet. Kindly may period 5/5/2025 office note.
You have not taken justice service?
My lord, what happened, my lord, initially justice service was given, my lord, we took justice service, my lord, but when we approached the respondent.
Okay, so and so appears on behalf of the respondent numbers 1 to 5, huh?
Yes.
And Mr. So and so appears on behalf of the respondent number 9 to 12. Full stop. It has been brought to the attention of this court by the learned counsel for the petitioner, the respondent number 6 to 9. 6 to 9.
6 to 8, my lord.
6 to 8 are the sons of
Sons and daughters.
sons and daughters of the respondent number
4, my lord.
4. Full stop. It has also been brought. Are they all being represented together before the trial court?
Yes, ma'am.
He further submits that all these respondents are being represented together by are being represented together before the learned trial court. Full stop. Taking into account the above, this court deems that the service upon the respondent number 1 to 13, 1 to 12
1 to 12, my lord.
are duly complete. What about 13?
My lord, 13, my lord, in the morning, my lord, one advocate might have informed me over telephone that he is going to file a Wakalat now, my lord, but because of.
So list this proceedings for admission on 20/30/2025. Mr. Counsel, get your things
My lord.
corrected.
Respondent number 4 is Reena Begum, daughter of Moina Mia, and 6 is Nazmul, son of late Siddiq Ali. So
Are you all representing together in the suit or not?
yes, I have to take instruction on that, my lord. Presently, I am appearing for 1 to 5. Yes.
Okay. Chalo.
Much obliged.
35,
It is only a consolidation. We don't want to delay the matter. Kindly help in the aid of for the trial court to decide the proceedings, not before this court keeping the matter pending would not help in purpose. Yes, what is this? Item number 35?
35,
And appears on behalf of the parties to be matter be listed again on 26th of May 2025.
36,
Yes, what is this modification?
Lordship, issuance of notice in respect of response number 5 to 8 was waived off, my lord. In fact, my lord, response number 7 and 8 are the parents of the victim, my lord.
Oh, sure.
7 and 8. 5 and 6 not required, my lord. 5 and 6. 7
Yeah,
and
right? 1, 2, 5. Taking into account the submission of AR, instead of the name of the respondent may be struck off. Taking into account the submission, the respondent is struck off. Who are 5 to 8?
5 is the driver, 6 is the owner, and 7, 8 are the parents of the deceased person.
So 7 and 8 is required.
7 and
5 and 6 is not
Not
required. Full stop. There is an application filed for correction of an inadvertent error in the order dated 19/3/2025, whereby this court had directed for striking out the names of the respondent numbers 5 to 8. Mr. T.K. Kolita, the learned counsel appearing on behalf of the applicant submitted that the respondent number 6, 7 and 8 are required for proper adjudication of the instant appeal as they are the parents of the victim. Full stop. Taking into account the above, this court therefore corrects the order dated 19/3/2025, more particularly at paragraph number 2, wherein this court had observed that the names of the respondent number 5 to 8 be struck off. Full stop. This court observes that the names of the respondent number 5 and 6 be struck off. Full stop. This court modifies the said sentence in paragraph number 2 by observing that the names of the respondent numbers 5 and 6 be struck off. Full stop. However, as regards the respondent numbers 7 and 8, the petitioner is that the applicant would take steps by way of registered as well as usual. Full stop. Usual. Full stop. The instant order be a part of the full stop. This court further observes that the applicant the appellant shall file a fresh memo of parties whereby striking out the names of the respondent numbers 5 and 6 and 5 and including the names of respondent numbers 6 and 7 within 7 days.
7 and 8.
7 and 8. 7 and 8. 5 and 6 যাব 7 and 8. Full stop. After I stands allowed. Or main appeal this court by an order dated so and so to this order in ISS so and so had made a correction to the order dated 19/3/2025, whereby this court had corrected the order dated 19/3/2025 to the effect that the respondent number 5 and 6 be struck off. And however, the respondent number 6 and 7 shall remain, 7 and 8 shall remain in the instant appeal. Full stop. Accordingly, this court directs the appellant to take fresh steps upon the respondent number 7 and 8 by way of registered as well as usual. But within 7 days. Right. Okay. On 1. Baki no? Hearing na? 1 and 2. Where is 1 and 2? 4. Oh, Muson, yes, Muson, Mr. M. Kamil. Yes, you have a case?
Admittedly, my lord, on the day when the suit was proceeded experting, on that day, my lord, 120 days was not completed. And my lord, to that effect, my lord, defendant has, my lord, cannot be blamed. It is, my lord, unexpected. Because, my lord, had it been on, my lord, 27/9/2024, my lord.
এই judgment আছে না কত গল judgment বো তাহলে কত গুছাই দিয়ে বল মই ভরে
That is
গেছি
the
না
contract.
dismiss করে বললে কি judgment তো কত আমি গুছাই দিয়ে গেল এই তো আছে পাইছি tell me I can't help you you should have filed
Sir, I am not praying for negative equality, my lord, but I am not praying for negative equality, my lord. But my lord, here, what has happened, my lord, the plaintiff, my lord, were serving the copy of the documents, they sought for 8 months' time. And my lord, the matter was fixed on 19/9/2024 for filing ex parte evidence. Till date, they have not filed the, my lord, evidence.
that is a different thing but you see if I allow you you should have filed your thing I know the lawyer made the mistake
Yes, my lord.
lawyer made the mistake
Even, my lord, I am conducting that particular case before the trial.
let me have this on Friday. Let me think what can be done.
Yes.
I want to, but otherwise my hands are tied.
Yes, yes, I understand.
My hands are tied. That is the main problem. Because the moment I start doing something here, Mr. Dutta, you have to also understand. The moment I give you something here, it will open a floodgate. The basic intention behind the amendment to the Commercial Act, Commercial Codes Act will become useless. That is why the Supreme Court was very clear. Find out, there might be in some cases the Delhi and Bombay, something must have been done. Find out, then give me something to the. Think about the case if somebody dies, something happens. Person must have died.
I have searched, but my lord, whatever directions have been passed in regard to, my lord, defendants, my lord, whatever judgment I have come through, my lord. But my lord,
What?
in regard to, my
No,
lord.
this is
plaintiff,
an
my lord.
ingenious method. You knew it. You should have immediately filed a written statement then.
Yes, yes, that was my mistake, my lord. If I could,
And I tell you one thing, 90 days is the period. 30 days is the grace.
no, here, my lord, 30 days is the period, 90 days is grace.
No. Here also, the 90 days remains.
Yes,
Here, initial 30 days.
initial 30 days.
But 90 days is the grace, but cannot go beyond 120 days, which is made it very specifically clear.
That I understand.
Then how do I imply?
But my lord, when, my lord, the order of ex parte order was passed, on that very date, my lord, 120 days was not over. But my lord, it is also true, my lord, after, my lord, within that 8 days remain, my lord, to complete the 120 days. And within that 8 days time period, my lord, I have not filed my written statement. Because, my lord, the court has fixed the matter, my lord, on 29/11.
You not to look out. You should have filed it on the update. Because the court had made the mistake of giving you, allowing it, then also I can help you. I can't help you there. Let me have it on Friday. Let me have a think. Anything. But the only worry, Mr. Dutta, is this. If I allow you here, it will open floodgates. One is very careful. That is why I fixed it after 2 weeks. Some other judge would do it.
Then, my lord, may have it on after 2 weeks, my lord, in the meantime.
I
will also-
gave you, that is why I said, leave the matter after 2 weeks.
I will also, in the meantime, I will try my best to search the judgments, my lord.
Don't
They-
get
they
it
may
back
be fixed,
again
my
to
lord.
me.
Timing item 1 and 2.
Obliged.
Conscience does not permit. So the moment I do it, I know this is going to have a problem. Anyway, let me have it on Friday. Let me have it.
Obliged.
This is the matter again on Friday. Yes. Tell me.
My lord, the issue at hand is now very simple, my lord, very narrow compass. The issue is, my lord, that the learned trial court and the first appellate court have said that there will be 7 shares of the pension. 5 sisters, mother of the deceased, and the son. Now, after the substantial question of law framed now by your lordship, the question arises whether, my lord, the son would be solely entitled or whether anybody else would be entitled. My lord, two aspects of the matter. One is that, my lord, the sisters, the 5 sisters, because they would take 5 shares otherwise. Under what provision of law, my lord, either under Christian law or under the bank regulations, under no, my lord, concept of law, my lord, they are entitled anywhere. They do not have anything to do, my lord. They have no share whatsoever. This is not a case like a Muslim law, where there is, you know, if the person dies.
The mother has died, na?
No, mother is still alive.
Mother is alive.
Mother is alive. Mother is alive. Now, my lord, if your lordship would see that the bank regulation, it says very clearly that it goes to first the widow, then the child, then, my lord, if there is no widow and no child, then it goes to the parents who are wholly dependent of the deceased. But in this case, there being a child, now the child's share has been upheld both by the learned courts below. That aspect of the matter is not under challenge. So his share is there, my lord. So my humble submission is that, my lord, he takes fully, because the bank regulation says the mother or father would only come into the picture once the, my lord, there is no widow or no, my lord, child. That is the short summary substance of the case, my lord. As far as the widow is concerned, my lord, lordships are aware, my lord, this is not a case of a legitimate marriage. My lord, we will not press on that aspect. But as far as the child is concerned, my lord, he would even otherwise have a share. That share has been there. Instead of 1/7,
let me tell you one thing.
Lordship.
Child has been not defined.
Child has been, my lord, defined in the bank regulation, which I have placed, my lord, for your lordship. My lord, the 1995 regulation, my lord. Child, it says, my lord, means a child of the employee. Because it is 21A, 21G, my lord.
Here till 5 o'clock.
Good. '95 regulation.
95.
Regulation. The Central Bank of India employs
Means a child of the employee who, if a son is under Iman. Widow.
Widow is not defined. Family is defined, my lord, 21O, my lord.
Huh?
21O. On the next page, family in relation to an employee means, my lord, A, wife in the case of a male employee or husband in the case of a female employee. My lord, then a judicially separated wife or husband, we are not concerned, my lord. We are concerned with, my lord, C and D, son or unmarried daughter or widowed divorced daughter who has not attained the age of 25 years, including such son or daughter adopted legally. D, parents who were wholly dependent on the employee when she was alive, provided the deceased employee had left behind neither a widow, widower, nor a child.
So if you can't be a wife,
Lordship.
regulated by the general law, you would not come within it.
No, that appears to be the
Even
intention.
though, if you see B, a judicially separated wife or a husband, such separation not being granted on the human being has 20 years. Parents who were wholly dependent on an employee when he or she was alive. So you mean to say, if a wife is not judicially recognized, or the general law does not recognize a law, because that is the finding of fact,
That is the point.
he cannot be a wife.
No, because then we would have to, my lord, go by the definitions, kind of definitions which are there in, for example, my lord, section 125 CRPC. So those definitions, my lord, in my humble submission, perhaps would not apply to regulations of this nature. Because otherwise, perhaps there would be an aspect of chaos. Lordships are aware there are a number of judgments in earlier times. Rameshwari Devi is there, my lord, other judgments are there. But those are all, my lords, on the question of, my lord, either 125 CRPC or in connection with the Hindu marriage. Here, my lord, both the courts below have held that there was no valid legal marriage either under the Hindu law or under the Christian law of the deceased and the appellant number one. But that being the finding of fact, which, my lords, with my humble submission, I am unable to, my lords, challenge, because, my lord, the finding of fact as such, my lord, that it is difficult to prove that there was indeed a valid marriage, even under the Hindu religion, because the deceased was a Christian, he was following the Christian religion. So first of all, my lords, the law laid down by the Supreme Court is very clear. There has to be a proof of conversion to the Hindu religion by the Christian, and then only the marriage would be recognized, because the marriage under the Hindu Marriage Act has to be between two Hindus. It cannot be between a Hindu and a person of another religion. Because if that be so, then Special Marriage Act has to apply. That was not the case. So that being the finding of fact, my lord, I am unable to challenge that finding. So as far as the wife is concerned, my lord, my submission, my lord, that perhaps she would not be covered by this, because this is
The wife will be out,
wife will be out, my lord, because unlike
because the general law prohibits.
and unlike 125 CRPC, which has a specific, my lord's, intention of preventing vagrancy and destitution, bank regulations, my lord, or regulations of pension regulations, my lord, specifically are not, they have to be construed as they are. They cannot be construed, my lord, more than they what intended. For example, my lord, if I may say, my lord, if the question arises whether a illegitimate son, I would not like to use the word, that word has been deprecated, my lord. Let us say a son who is not, my lord, the product
If
of
the
a marriage.
statute have uses the word illegitimate, then who are you not to use?
No, my lord, the Supreme Court,
Doesn't section 16 uses that?
that is there. The Supreme Court has recently deprecated the use of this type of
Can't
word.
help it, the Supreme Court has done it, but what do you do?
No, my lord, if
Supreme Court also says that nowadays you don't refer to the you don't refer the
lower court,
district judiciary as
As the lower.
subordinate judiciary.
subordinate,
But the problem remains, how do you write then Article 235,
that is there.
227?
My lord, herein, my lords, if one sees, my lord, this clause, subclause C, then it would seem that including such son or daughter adopted legally. Because if it be the submission of the other side, or my lord, I'm assuming for the sake
Wait,
of
wait,
this, my lord, this subclause C of family, my lords, family, son or unmarried daughter or widowed daughter, who has not,
Age of 25
yes,
years.
including such son or daughter adopted legally.
Where is adopted legally means?
My lords, adopted legally, my lords,
Wait.
an adopted child. Family, my lords, definition of family, my lords. 210.
Oh,
Yes. So, my lord, if
wife in the case of so and so.
the wife, no.
Or not daughter.
See, my lord, son.
Huh?
Son or unmarried daughter or widowed divorced daughter who has not attained the age of 25 years, including such son or daughter adopted legally. My lords, here would be a case where my natural born son would be deprived of the pension, because if he takes, then he takes in full. There is no question regarding the application of C and D. So he can't be thrown out. He has his share. That share has been upheld by the learned courts below and not challenged by the others. So his share is there. Now the only question remains, two questions, my lord, which your lordships would have to go into perhaps. One is, under what provision of law, my lord, under which law the sisters would have a share? Because the sisters, the 5 sisters, they are completely out. They are not part of, not coming under the definition of family at all. And if they are not coming under the definition of family, my lord, the learned trial court as well as the learned first appellate court has not even entered into the question as to under what law they are eligible. Simply they have allowed the suit and dismissed my appeal.
No, they made it eligible as per the Hindus, Indian Succession Act.
Indian Succession Act, my lord,
Where the wife, daughters get
will
it
not
in
apply, because this is a case of pension. Pension will go by the pension regulations.
Understood, but there the daughters have the right.
Yes.
That
They
is
are the
how the
daughters.
court gave it.
My lord, they are the daughters that have right, but the learned trial court, my lord, has lost sight that if they allow these sisters, my lord, the son and the sisters cannot both have a right, even under the Indian Succession Act, as far as Christians are concerned. Admittedly, the deceased was a Christian. Now, if the son gets as a Lilian descendant,
And then the sisters
then
then
the
don't get.
sisters are out. So, my lord, this is the case, my lord. How can two clauses be taken from two provisions and, my lord, mixed up in this? This is a case of misdirection in law, my lord. The trial courts and the first appellate court perhaps had a very noble intention of doing justice to the parties. Very well. But the problem is, my lords, that you cannot take one, my lords, clause from here, another clause from there, and create a Frankenstein of law and say that, okay, I am having share, giving 7 shares of the pension. No, they have to justify it. And there is no, my lords, reliance on the provision, the provisions that they have relied on in their, my lords, pleadings pertains to parties, my lord, under the Succession Act. No application to Christians.
Is there any judicial opinion on this?
No, I need not.
On this, when you interpret the pension rules and all, there
No.
has to be, how
It-
do you do it?
It has to go as per the pension regulations only. Violate
Understood.
Isaac
No,
ruling
that
is
is
the
okay,
Yes.
but we are only concerned with the pension.
pension, only pension. Rest of it, my lord, has already
Have
been
already
addressed.
been appropriated.
Yes, for the loan.
The loan on everything has been appropriated.
Yes. In fact, my lord, the loan is still outstanding.
Bank's council can say, but
No,
Basically,
no, you told me last
this is,
time,
some amounts are appropriate.
some amount or entire?
No, that is not.
no, my lord, the entire amount as per my instruction, apart from pension, nothing is left. Because
You
there is an
also know.
outstanding loan.
Find it out. The
We are-
matter going on from 2015, I mean, it's not known. So getting a bank in these type of matters, they're not least bothered. Their only thing is that we are going to pay, we'll pay whoever it is.
Yeah.
We have kept it out there. We are not bothered. They are not bothered to that effect. So if you don't find it out, so what to do?
Now, the reason for the, why these amounts were appropriated was that a loan was taken, my lord, by the deceased. And after his death, apart from the pension, the entire amount, whatever little amount was there, they have appropriated, and the loan is still outstanding, my lord, and I have to face a SARFAESI notice. A SARFAESI Act notice has been issued to me a few years back in 2011, in respect of that loan which was taken in by the deceased. So even if I get the pension tomorrow, in all probability, my lord, the bank may resort to withholding that amount. That is there. So even the SARFAESI Act has been invoked against these appellants. Though till date, they have not got 1 paisa also. That is the fact of the matter.
But they have not appropriated.
No, they have appropriated everything apart from the pension. Pension, because it was subject matter of this proceeding, so they could not do anything. And anyway, my lord, there are a number of judgments which say that in the recovery of loan process of a deceased employee, pension cannot be stopped like this to be payable to the legal heirs. But that is another aspect of the matter. Now, the only question is that, my lord, as far as this 95 regulations are concerned, whether, my lords, he will take wholly or he will have to share. That is the. Because even
Have
if
you
they
not
share-
found out any judicial precedent in respect to an illegitimate child
No, my lord, the only
as regards pension?
pension, my lord, there are some judgments, my lord, but those pertain to some other regulations where the language is not, my lord, my lord, matching with this.
No, not matching, but how the courts have been interpreting.
As far as compassionate appointment, my lord, lordships are aware that that part of the issue has been settled now by the Supreme Court after Mukesh Kumar and other judgments. There's also a very enlightening judgment of Justice Nagaratna when she was in the
What
country.
does the Supreme Court say?
Supreme Court have said, my lord, that as far as the child is concerned, the son is concerned or daughter is concerned, legitimate or illegitimate, it's no bar, my lord. If there is a proof that he or she is the child of the deceased employee, because ultimately, my lords, for compassionate appointment, what has to be seen, Supreme Court says, is the aspect of dependency. It has to be a dependent. The son or daughter has to be a dependent. He may be
Where is
illegitimate.
the judgment?
Well, there are a number of them.
But if I have to write the judgment, I have to also,
Yes.
there is no
They
direct
directly,
judgment
my lords,
on
on
the
this
I
point,
have to bring it somewhere from somewhere. the problem is Hindu.
Yes, all these judgments.
You see, this paragraph which is there is disastrous for you. Paragraph
One,
7.
I have one in respect of a Muslim also from the Madras High Court. In that case also, my lord, even an illegitimate son, my lord, was given the compassionate appointment pertaining to a Muslim person. So
Given?
I have, but not to him. I went on this. But that being the case, my lord, even otherwise, my lord, there is a judgment of the Karnataka High Court, which has not been set aside till date, Justice Nagaratna's judgment, in which he has said that if I would just place for a minute, my lord, that judgment. SLP has been filed, my lord, I must clearly say, my lord, that.
This is what?
Well, this is also, my lord, as far as Hindu is concerned, but there are certain observations, my lord, here, where irrespective of the religion part, my lord, that
Tuesday. The hearing remains inconclusive. Next matter next Tuesday, 2 p.m. You get all the photos.
I have already referred a judgment of Madras High Court. I have already referred a judgment of Madras High
Which one?
That is S. Kamalam versus Selvaraj. Kamalam versus Selvaraj.
that is in respect of
Paragraph-
wife, I believe.
Paragraph 22.
In Nirmala.
S.
In that.
S. Kamalam versus Selvaraj, decided on 8 June 2010. Can I supply you? No, regarding Stan.
Agnes Karappa Devi. Who has given Madras High Court?
Madras High Court.
Judgment dated 7/11/2010.
No, it is 8 June of 2010, paragraph 22.
Huh?
S. Kamalama,
Oh, yes, Kamala.
paragraph 22.
You will find it in somewhere, na? What does it say? This is for Christian?
Yes, Christian. The instant case is, my lord, this is a Christian.
Hello.
Illegitimate chance are not intact.
This is not reported in SCC online. Find it out.
I will.
Madras, oh, this one. And P. Munindi is yours.
No. I have placed one earlier one judgment of the Kerala High Court, Jane Anthony versus VMCI. But Madras High Court is contrary to that. Takes a different.
It is next Tuesday. Yeah, 27 at 2 p.m. It is the same.